Page wise mentioning, page number 1, item 1 to 13, page number 2, item 14 to 25. Page
Item number, Millard, item number 25, Millard. I am for the respondent.
Yes, sir.
I am for the respondent in this matter, item number 25.
Yes, sir.
I may kindly put it, 1 week time may kindly be granted. I am out of station.
Post after 4 weeks.
Obliged.
Page
Obliged.
number 6 to 38.
For the period 6 and post after 3 weeks.
Page number 4, item 39 to 48.
Item 41 year. No, sir. They can go outside and Maraha. For 3 weeks. I'll come directly. Okay, the matter. Look at fight. Post for it. Because he's supposed out of 4 weeks. After about 4 weeks. Yes, sir. And wait, sir. Then we'll wait on our turn.
Page number 5, item 49 to 61.
Item number 51, my lord.
Wait, sir. Yes. Sir. Item number 51.
My lord, the original suit here is dismissed for default, my lord, and they filed a set-aside petition under Order 9, Rule 4, my lord. It has also dismissed on 11/9/2023, my lord. I have filed a certified copy of order copy of the learned additional senior civil judge Gadwal, my lord.
Already 6 and post after 4 weeks.
Item 60, my lord. I am for the respondent, my lord. I request my 3 weeks time, but I inform the other side.
54. Everyone side, madam. Madam Praveen Kumar. I'll inform. For 6 and post after 3 weeks. Item 54. Yes, sir. What is your name?
Item 60, my lord.
Item
But I
60.
request. Yes, I request 3 weeks time, but I inform the other side. But I am for the respondent, not I felt vacate. I inform the others.
Post after 4 weeks.
Okay.
Page number 6, item 62 to 71. Page number 7, item 70 to 84. Page number 8, item 85 to 97.
Your Lord is like 87. Your Lord is like that. At least 2 rounds. Get gospel. Apply 6 times. Post after 4 weeks. Right.
Page number 9, item 98 to 112. Page number 10, item 113 to 128.
Item 123. The appellant requested 3 weeks time. I'm already informed the
Okay.
entry model.
Then wait, sir.
Already informed the other side to get to the extent of it.
Yes, sir. I'm reaching only. Yes, sir. If you reach today itself, I will extend in the bar. Sometimes we don't reach. I will the matter. Yes.
Page number 11, item 29 to 143.
Item 138, Your Lordship.
Yes, sir.
I am representing B. Shivkumar, Your Lordship, representing time, Your Lordship.
Hospital and 6 time. Post after 4 weeks. Item 1. B. Shivkumar.
Page number 12, item 144 to 158.
There's a creator in the matter accept the notice and informed him. Taken up after Sunday court.
Even for Rakhi Sangeet. Hospital after 6 time. Post after 2 weeks. Western is matter, this is. Western is most of this matter.
Yes, yesterday it was posted.
Yes, yes.
caveat is there also.
Okay, okay.
Page number 13, item 159 to 171.
71.
Yes, madam. Representing whom, madam? Representing whom? To borrow matter. Everyone outside. Then wait, madam. I will adjourn the matter. I will adjourn the matter, and I will reach it. I will adjourn the matter.
68. This matter, you got insurance company, not served you are. Why from the judge who might have is nothing but one of the.
It comes for the appellate 6 and post after 4 weeks.
Page number 14, items 170 to 180. Page number 15, item 181 to 192.
Madam, 182 to 190. 192. Disposed of. Item. It went up. Item 182 to 192. Disposed of.
Page number 16, item 193 and 190.
Post for the. You are one. Item 194. How will it matter? Who filed the petition, sir? Who filed the petition? The petition filed by? Okay. Post is matter. Here comes. It is possible the post for orders after 1 week. It's after 1 week, sir. For orders, like a moment for post for orders after 1 week. Outside, so not here. We are not. Yes. After as per orders, pass after the orders. One by one, sir. From state. Yes, sir. What happened? What listing of the case? One listing of the case, madam. Where is it? Post after 1 week. Yes. Monday. Monday, sir. When was expired, sir? When was expired? When was expired your interim orders? The wait for 1 day, up to Monday.
Year of the year 2022.
Post after 2 weeks. Post after 2 weeks. After 1 week. Yes, sir.
Transfer the petition to judgment of operation. Order is not uploaded.
Already signed, sir. Long back I signed, sir.
20th October.
Like PS also not been. They will on leave for 4 days. Already I signed last week, sir. I've already signed. Not nice, sir. Football. We were with what else, sir? Not nice, sir. Number this one. What is the number?
245/2020.
How many back I was signed? Yes, sir. Monday, sir. Tuesday. Okay, I'm going to Monday. Monday, sir. Yes, sir. What are 2 weeks? We'll see after 2 weeks. Yes, sir. After 2 weeks. We start back. 2 weeks. Sir, adding up this 2 weeks, sir. You want to give the city, that's 2 weeks. Yes, madam.
Increase on extension, Lordship, this date of disposition to your Lordship.
Madam, Tuesday, madam. Yes, sir.
Date of disposition, Lordship, the legal.
No, madam. It's not Tuesday, that's the madam. Yes. Post out of 1 week. Yes, sir.
Because the applicant in the CRP, two CRPs are filed, two CMAs are filed. Both the CRP.
Post matter after 1 week. Sir. Yes, sir. What happened? Already over, mentioning over, sir.
I informed the other.
In demands and the driver. Okay. Apply 6 for 2 weeks at 120. Again, that's a problem. Again, you are coming and asking for. Wait, sir.
I've already informed the other side.
Okay, we'll see. Nothing. Call the list.
Next item number 1. Now let's come on.
Yes, madam. Okay, what the? Yes, yes. I have an order. I have to hear calls for the petitioner. Develop respondent number. You are for respondent number 1, 2, 3, sir. Yes. But wait for all dogs. Respondent number 3. Yes. Yes. No, sir. You find only 2, sir. 1 and 2 only. 2 is the minor. Yes, sir. You find the KVH for respondent number 1 and 2. Yes. You find KVH for only 2. I have an objection, sir. One company there is no relation to deposit amounts to the. Already have deposited, but there is no not to withdraw the amounts for the minors. Only what I have said, there is a condition that not to withdraw the amounts by the minors. That's actually how one regard mission only was taken by the petition. Every petition was only 2 petitioners, not for the 3. Again, signature will be there. What about 3 sir? Shivakantamma. I'm asking for Shivakantamma. Saroja. Sir, you are 5 Saroja and Saroja Shamani, sir. Not for the Shivakantamma. Specifically, I'm seeing the petition. Only if I don't have 2 petitions, not for 3rd petition. Yes, permitted to the. I want to understand. Get possible petition. Probably, you would have the span number 1 and 2. We have 53 days. If I get control. I agree. Get possible petition. And it was for the respond. You would have the respondent. This is self DC number updated up to the don't have dated. Then some of the total on the file. Commissioner for employees, compensation, deputy commissioner for labor. Yes, as part of 1, 2, 3 submitted to the superhand to pass amounts in the account. DC number 170 on the file of employees, compensation, deputy commissioner for labor. Adequate because financial security. Main case, it meets. What should the respondent number 3 and 3 also taken account. 3 also you are. Yeah. 1, 4. 4 of 8. Yes.
Item number 2. Different from the item.
Yes, sir. Admit notice post of 8 weeks. Post of the take what?
Item number 3. Yes, Surendra Reddy.
Yes. Everyone ordered, I have to put suspense, post for 8 weeks, post for upland, take out post for service.
Item number 4. Yes, Sampath Kumar.
How many days today, sir? 12 days. 12 days, sir. 4 days or 3 days, sir. You have no idea. I mentioned 12 days, first place. One pretty section also. One place at 3 days or 4 days. Yes, sir. I have an order. I have to take cost for the petitioner. We have 4 days cut out.
Item number 5. Others Kumar.
Yes, lot 269. I have an order. I have to put respondents, post of 8 weeks, post of take out, super service.
Item number 6. Case difference combined.
Yes. I have a process plans, post of 8 weeks, post of take out, super service.
Item number 7, Krishna Kishore Komuri.
Yes, sir.
It is delay. There is a distance with them.
I have an order. I have dominant delay, sir. 52 days, 1 year almost. Process fine. Post for definite. Take out copy of the service.
Item number 8, please read first.
Yes, sir. Sir, good page. I have an order. I have 2. Not suspense, post of 8 weeks. I have 3. Stay. If you learn around capacity 6 weeks, make it for 8 weeks.
Milord, I am appearing in this matter, respondent, Milord.
File local up, madam.
Item number 8.
File local up.
Item number 9.
I have an order. 10 case entry, notice, post of 8 weeks. Also, can check out for service.
Item number 10, major
Yes,
secretary.
sir.
And the patient. The appellant before your worship, but suit for perpetual injection was filed by the respondent here. But seeking perpetual injection. But the same suit was dismissed. But after the dismissal of the suit, carried in the appeal, it was allowed.
Yes.
Agreed by the appeal.
At the lane,
Plus the lane is with regard to 3 feet. But even the plaintiff, that is the respondent, he is also not the owner. But the suit itself is not proper. Lordship will say that the representative capacity, the learned trial court rightly held that you should have filed suit in the representative capacity. And to that effect, they have also filed an IA seeking the leave. That the page 37. Page 39, your Lordship.
yes, sir.
Page by second paragraph.
Yes, sir.
Having written the 3 lines before. Then pleading itself, it is clear that the suit filed by the plaintiff is defective and is not maintainable in the eye of the law. As they have no local standard to seek a relief of mandatory injection, respect of a common lane in their individual capacity, when it is meant for use of public and not the plaintiff's road. But having realized the said incurable defect, the plaintiff has filed a petition IG number 139 of 2011. After trial, is already commenced. Even evidence is already ready. In on behalf of the plaintiffs to accord permission in the proceedings with the case in representative capacity. But the said IA 139 of 2011 is dismissed by this court. By order dated 7/9/2011 by clearly holding that the petition is not at all maintainable when once the suit is made. But this suit was given the suit has not have been filed in the representative capacity is one. But we learned first appellate court came to
I want to find it.
but came to a conclusion with regard to the easementary right. But learned this came to a conclusion that easementary rights prescriptive the Lordship will find. Page 18. Page 18. Para 28. Section 32 speaks that right of enjoyment without disturbance. The owner or occupant of the dominant land is entitled to enjoy the easement without disturbance from any other person. Section 35 speaks that injunction to restrain disturbance subjects to provisions of specific impact to the injunction may be granted to restrain the disturbance. That the plaintiff acquired easementary right of.
So what are the issues favored by the?
But in fact, the easementary which learned appellate, first appellate court did not give the finding is not at all pleading. It is nobody's case with regard to the easement right. But issues are whether the plaintiff is entitled to a mandatory injunction directing the defendants to remove the illegal structure laid and constructed by him or the suit schedule land. Whether the plaintiff is entitled for a perpetual injunction, restraining the defendant from interfering with the enjoyment of the suit schedule property. Using the lending, but it is not at all a easement right. In fact, it is the observation, but they have purchased the property for 10 years back. Easementary right has to be 20 years. But there is a very substantial question of law. It's a reversal, not judgment. rush to see the first item is whether the plaintiff requires descriptive rights of easement of way over the suit schedule land with expressly the plaintiff purchase the suit schedule land 10 years prior to the filing of the suit, contrary to section 15 of the easement. The easement at section 15 says 20 years is admitted by the land applicant. Yes, it is 20 years, but still they are from 10 years they are using this as his easement rights will be granted. Is what whether that has to be dealt with.
They might also their is also the continue using the same line.
It is said that well, it is not at all. They say that it is the land is there from long back.
Yes, sir.
This is what is there. But admittedly, what they have not pleaded with regard to the easement right. That insofar as the easement right in the appellate stage, the advocate commissioner was appointed. The all process took place. But the suit itself doesn't. But all this is not occur.
Show me that copy.
Let 53 version. It says there is a lane behind the house for which we are using. Para 4. Page 54.
Yes, sir.
But the northern side of the above said purchase house, the lane is like this. So we should leave it with this to be main road of approach. But this lane, but he is not claiming as an owner. Absolutely. But the suit itself is defective. Once the suit is filed, then it should be order 8 rule, which I also read the substantial question. The third one is that whether the suit filing plaintiff is hereby order 1, rule 8 of the CPC. Then in the representative capacity. By sufficient people, the suit itself is not maintainable. That means so well, there's a clear finding by the trial court. The suit itself is not maintainable, but it's hit by order 1, rule 8. CPC.
Order
8, order 1, rule 8. Suit there.
Yes, sir. One person may sue or depend on government.
Yes.
All in same interest.
One person may sue or defend on behalf of all in the same interest. Because there are numerous persons having the same interest in one suit. One or more of such persons may, with the permission of the court, sue or defend the suit on behalf of all the participants. But it's a public place, even according to me. That he is claiming individual right, not an individual capacity. That is not. But it was also the case for the municipal corporation. But all the lanes, if it was there, it will not invest in the local body. But they are not made party.
Yes, sir. Here comes. Left. Over the cards. Can I please? Following. Stop law. AP.
Item number 11, K. Venkateshwari.
Yes, sir.
Only question of before the as not repeat at that time the red card.
What are the values, sir?
100 rupees.
400 rupees. Record notice, sir. Resolution. Post of.
Item number 12, G.P. Parokar.
Yes, sir.
Petitioner is the wife, my lords.
Where is our bid, sir? Sir,
Pardon.
verify your bid. Where is our bid? Page number. What is the contract?
Page number, my lords.
Show me, sir, the bid.
My lords,
What is the bid?
page number 1, I have stated, my lord, para 2, that the instant application is filed for transfer of DOP number so and so,
Sir,
filed
page
by
number.
the respondent.
Yes, sir, that is prayer. Petition copy, that is. Where is the bid, sir?
Mail petition, your lordship, sir. My lords,
You have clarified a different bit of bid, sir, not of bid.
I am
You know
sorry,
that?
your lordships are right. Only stay petition is there before your lordships, my lords.
Yes, sir.
I
That's why
apologize, my lords.
I
I
put one
cure
week.
it, my lords.
I put out 1 week, sir. You have
I
clarified
can-
a different bit of bid, not by the.
Your lordships are right. Only stay petition is there before your lordships, my lords. Kindly accommodate me, my lords. I
1 week,
apologize.
sir. Now, 1 week, fine.
My lord, your lordship may have it on Monday. I'll cure it tomorrow.
1 week, sir.
Okay, congratulations.
Item number 13,
Item number 11.
Yes, sir, permitted.
item number 13, R. Neeraj.
Yes.
Studies of life. Respondent has been filed a petition before the senior civil judge court, arrangement for resolution of. That is taking a transfer matter because petitioner is having a child of 18 months. And, case where respondent has been. And his family members have observed her, some differences created between the petitioner and the respondent.
Yes, sir. Dollar file 488.
She has already filed 498.
Foundation. Post office. Please. Constable. Petition power take out from file for service. I have. This is shall. It's working on the 23 on the file. Serious villages. Naranpet. Yes. Right.
Item number 14, G. Swati, S. Surendra Reddy.
Yes, sir. What is it? Fine. No, I have fine. Other mention. Okay. Petitioners. Speaking. Petitioners, petitioner. Yes. I have five here. Order. listed. Visakhapatnam section madam. Already ordered. Last application last.
Item number 15, he is Praveen Kumar.
Yes, sir. Last application. There comes for releasing the submitted. The matter being likely to be compromised between the parties and each time. And for the petitioner seeks time. The file dealing to for orders. Already against the lordship already. Orders, they are to 6 and 2. Compromise the matter.
All admitted it will not they were depositing the rate the bank. But our bank report has not because it's for 2016 to 2020. Ultimate added to the black mark for the reason. But in the year 2016, the rate was 6,750. To the petition. There are there is some broker. This amount is paid with husband to mother, husband of the petitioner. From 16 after they said 6,750. Again, it was enhanced to 40,000. But submitted in the counter itself. Hardship says the lots counter. Page 20 lots my can be said. Their counter starts at page 21. Page 21 their counter starts at the fourth line. He said in the monthly rent for above mutual profit was sum of 35,000 because we enhanced the project rate table is 40,500 per month. They don't admit in the counter. For direct debit is sum of only. I say take up the thing before the final vote and I should stay and everything.
230. Okay.
Item number 16, he actually cannot see it. Session question.
Yes, sir. Pardon. Right.
The commission petition.
Subject to class. That's why I forgot.
Yes, submitted the
Judgment also. Post of comes.
That management is this board is branch to state. Checking the mistake will be calculated in this one. If anyone is asking this, they have to let us start other expectations. They are only cases they are very clear.
The matter, sir. Vacate. I am vacating in the matter. You see, sir. Separate petition, sir. You see. Yes.
Item number 17. B. Prabhakar.
Kindly liberty to the petitioner applied for filing fresh arbitration OP Millard. Grant leave Millard. To grant leave Millard for filing fresh arbitration OP to the applied Millard.
Where the question of granting leave, sir, you have got. You find appeal against the orders. Wrong forum. That is the opposition.
Kindly to grant liberty Millard.
So, abide your right, sir. Where the question of granting by leave by this court. Here comes the applied and opposition. Sustained. We shall return the bundle to the applied. Yes, sir.
Item number 18. N. Chandrasekhar Reddy, B. Adil Chandrasekhar, Chandrasekhar Reddy.
This is, I will find already stated condition in the year. And like, here it was the third by.
Style or something like that, sir.
It was reserved for 4 months. Was released.
I'm right. Yes, sir.
We have urgency alert. The respondent is aged about 70 years. And the suit pertains in the year of 2013. The suit for the eviction of the dependents.
What is IA? IA 54?
I find the stated petition that is item 2 of 34.
Imputers CRP, sir.
CRP, they find
CRP.
the 9 petition.
CRP.
Yes, sir. 909 petition that was dismissed by the lawyer. And I clearly mentioned in my counter, para number 2, my counter affidavit. And the entire proceedings I mentioned in para number 2, my counter. Since 6/12/2019, they are filing one petition and other. Counter affidavit is dependent evidence was closed on 6/12/2019 on 13/12/2019 no instruction. On the current hearing. On 31/12/2019 the charge enforced. Either on 21/2020. Thereafter they filed an IA. The 151 CDC to reopen this. That is by the year 49. Allowed the petition and payment of last 5,000 rupees. There are 3 responses. State.
I'm pretty tension second. This time to 2 weeks time. I will next week. This call is getting by. Is there?
All the petitioner. State step. State must be responded. Both orders after 2 weeks.
Item number 19. N. Srikanth.
Yes, sir.
Probably got discussed arbitration only was discussed. No other, that's a question of law. Only thing that the normal access. Only thing that
Wait, sir. Yes. Here they applied concept, sir.
This application is appealed, my lord, is filed under section 37 of the Arbitration and Conciliation Act, my lord, where it does not require that substantial question of law is to be raised, unlike the CPC amendment. Section 37, if I may read for a moment, because that objection was first taken, I thought I'll address it.
Yes. Madam,
Section 37.
yes, madam. Appealable orders.
Notwithstanding anything contained in any other law for the time being in court, an appeal shall lie from the following orders and from no others to the court authorized by law to hear appeals from original decree of the court passing the order, namely refusing to refer the parties to arbitration under section 9, granting or refusing to grant any measure under section 9, setting aside or refusing to set aside an arbitral award under section 34. Lord, this is the order of the civil court, my lord, against which the present appeal is filed. There was an arbitral award, my lord, against which an application under section 34 was filed to set aside. The district court, my lord, refused to set aside the arbitral award. Hence, the appeal has been filed under section 37, my lord. My lord, coming to the facts of merits of the case, my lord, I'm challenging the arbitral award under two grounds, my lord, specifically. One, my lord, being that the appointment of the arbitrator itself is illegal. It is contrary to the Act and several judgments of the Supreme Court because the arbitrator was unilaterally appointed by the respondent number 2, my lord, without the consent of the petitioner herein, who is the borrower. The Honorable Supreme Court, my lord, has said that such unilateral appointments are illegal, and therefore, once the appointment of arbitrator itself is illegal, my lord, any action taken or any order passed by such an arbitrator becomes a nullity, my lord. It's a null and void order. My second argument, my lord, my lord, is based on the judgment of the Honorable Division Bench of this Honorable Court also, my lord, that under section 29A of the Arbitration Act, my lord, take a moment. My lord, the prior to amendment has to be seen, my lord, which is also extracted in this particular judgment. That the award has to be passed by the arbitrator mandatorily within 12 months from the date of appointment. But admittedly, my lord, I can show here from the award itself that it was passed beyond 12 months. This Honorable Court Division Bench of this Honorable Court has held that such an order passed beyond the period of 12 months where there was no extension of time granted. In fact, prior to amendment, there was no provision for extension also, my lord, of the arbitrator's mandate. So once the mandate of the arbitrator is completed in 12 months, then the arbitrator becomes countless of issue, and therefore an order passed, let me see, paragraph 17 of this judgment. Your lordship with the, I can take your lordship back. Paragraph 17, my lord. The dispute raised in the two divisions were covered by unamended section 29A. The amendment was brought about on came into force on 9th August 2019, my lord. The award is passed in 2017, my lord. Therefore, the pre-amended provision. From the dates and events of these two cases, it is apparent that the concerned arbitrator passed awards after 1 year of entering appearance. They declared functus officio 1 year after entering appearance and were wholly incompetent to deal with the disputes and pass awards. Thus, awards passed with arbitrators are nullity and void ab initio. In law, there will not exist awards, and therefore the question of enforcement of the awards do not arise. The execution court grossly erred in not appreciating this aspect. Lord,
Same.
Sriram, same matter. Same party. Yes, that the respondent is same group manner. Sriram Finance is in fact the same manner. I apologize. I understand that.
Sriram City Union, same manner.
Same manner. Sriram City Union Finance. Same respondent.
Srikanth also.
But let me see page number 26 of
yes. The Ganganagar and Srikanth were also paid.
Question has to pass within a year.
Let me see, my lord. Page 26 of my appeal menu.
Yes, madam.
This is the award pass, my lord. Copy of the award pass.
Dated 14th
Yes,
July
my lord.
2007.
The date 14th July 2017. Now, my lord, may come to page 30, my lord. Paragraph 3, my lord, on page 30 is there. The claimant company has filed its statement of claim on 31/3/2016. The award is passed on 14 July 2017. For a period of 12 years.
3 months.
Regard to Balanced 29A, there is a after completion of trading 1 year. Is there in the Act Balanced 29A? Is there?
So commencement of arbitration, which where commencement of arbitration, my lord, is on the date of appointment of the arbitrator or on the date of first hearing. Then judgment, my lord, because the pre-amended provision has to be looked into, my lord. Maybe the amended version. Enters reference, my lord. The award shall be made within a period of 12 months from the date the arbitral tribunal enters upon the reference. From the date of reference itself, my lord, not even from the date of first hearing. That is the amended version, my lord.
Completion of reading.
That is the amended 2019. It was amended. Now, let me see the judgment, my lord. We have the pre-amended section, my lord.
Para number?
Para 12, my lord. The issue raised in this division revolves on scope of section 29A. Section 29A is extracted, my lord. The award shall be made within a period of 12 months from the date of the arbitral tribunal enters upon the reference. For the purpose of this subsection, an arbitral tribunal shall be deemed to have entered upon the reference on the date on which the arbitrator or all the arbitrators, as the case may be, have received notice in writing of their appointment, which is prior to filing of the claim application, which definitely has to be prior to filing of the claim application. Claim application itself is filed in March 2016. So the appointment is prior to March 2016.
Yes.
My lord, the argument was also made, my lord, that since the award is passed post amendment, in these facts, my lord, the award was passed post amendment. Therefore, the post amendment section has to be taken. This honorable court, my lord, has said that that is not a position of law. Retrospectively, the act cannot be applied when the arbitration was already started prior to the amendment. Paragraph 16, my lord, we see. In fact, this case is better, my lord, because the award is. We see no merit in the contention of learned senior counsel that the effect of substitution of section 29A of the Act 1996 operates retrospectively and therefore the award made is legal. As held consistently, merely because word substitution is used, the amended provision does not relate back to the date of original provision that was amended. It depends on the language employed, effect of the amendment, and intent of the legislature. This issue need not detain further having regard to the intent of the Parliament. Section 29A was amended by Section 6 of the Amendment Act of dated 9/8/2019. By notification dated 30/8/2019, the effective dates of commencement of the amendments is notified. Lord, again, para 17, my lord, they said this prior pre-amendment will only be applicable. In fact, here, my lord, in the present case, the present appeal, the award is also passed prior to amendment in 2017 itself. The second, my first intention, my lord, coming back, you may see page number 107, 3 of the appeal document are tied to judgments of the Honorable Supreme Court, my lord, regarding appointment of the arbitrator. Section 11(6), my moment, my lord, for my benefit. Section 11 of the arbitration regarding appointment of the arbitrator.
Yes.
Appointment of arbitrators, I'll directly read section 11(6), my lord, which points to the application. Because, my lord, it says, my lord, subsection 3, my lord, failing any agreement referred to in subsection 2, my lord, subsection 2, subject to subsection 6, the parties are free to agree on the procedure for appointing the arbitrator or arbitrators. So there are certain restrictions on the manner and in which way the parties can agree also, my lord, in the agreement for appointment of arbitrators. Coming to subsection 6, my lord, where under an appointment procedure agreed upon by the parties, a party fails to act as required under that procedure, or the parties or the two appointed arbitrators fail to reach an agreement expected of them under that procedure, or a person, including an institution, fails to perform any function entrusted to him or it under that procedure, the appointment shall be made on an application of the party by the arbitral institution designated by the Supreme Court in case of international commercial arbitration, or by the High Court in case of arbitrators other than arbitrations other than international commercial arbitration, as the case may be. The present case is a domestic arbitration matter. There's no dispute about it. It's only the Honorable that can appoint the arbitrator under section 11(6) of the Arbitration Act. In this case, my lord, unilaterally, see on page number 55, the relevant clause of the agreement, loan agreement, is arbitration and dispute settlement. The font is a bit small. Without prejudice to the lender's right available to be under the RPC Act 2002, all dispute differences and or claims arising out of this agreement, whether during its subsistence or thereafter, shall be settled by arbitration in accordance with the provisions of Arbitration Conciliation Act or any other statutory modification or reenactment for the time being in force, and shall be conducted by the sole arbitrator to be appointed by the lender. My lord, the Honorable Supreme Court issued 103 PRF limited multiple judgments for them. Two of them I find along with the other judgments that I may also refer to in these. Page number 103 PRF limited versus NRCO Engineering Products Limited. From para number 23. Mary. Page 118.
Yes.
In Newton Engineering and Chemicals Limited versus Indian Oil Corporation Limited, a two-judge bench was dealing with an arbitration clause in the agreement that provided that all disputes and differences between the parties shall be referred by any aggrieved party to the contract to the sole arbitration of ED&R of the respondent corporation. The arbitration clause further stipulated that if such ED&R was unable or unwilling to act as the sole arbitrator, the matter shall be referred to the sole arbitrator or some other person designated by ED&R in this place who was willing to act as sole arbitrator. It also provided that no person other than ED&R or designated by ED&R should act as an arbitrator. When the disputes arose between the parties, the appellant therein wrote to the corporation for appointment of ED&R as the sole arbitrator as per the arbitration clause. The corporation informed the contractor that due to internal reorganization of the corporation, the office of ED&R had ceased to exist, and since the intention of the parties was to get the dispute settled through the arbitration, the corporation offered to the contractor the arbitration of substituted arbitrator, that is the managing director of marketing. The corporation further informed the contractor that if he agreed to the same, it may send a written confirmation giving its consent to the substitution of the named arbitrator. The contractor informed that he would like to have the arbitration as per the provisions of the Act, whereby each of the parties would be appointing one arbitrator each. The corporation did not agree to the suggestion given by the company and ultimately appointed Director Marketing as the arbitrator. Contractor being agreed moved the High Court of Delhi for appointment of arbitrator under section 1160 of the Act. The learned single judge dismissed the same and observed that the challenge to the appointment of arbitrator may be raised by the contractor before the arbitral tribunal itself. Interpreting the agreement, this court, Honorable Supreme Court, my lord, held, having regard to the express, clear, and unequivocal arbitration clause between the parties, that the disputes between them shall be referred to sole arbitration of ED&R of the corporation, and if the ED&R was unable or unwilling to act as a sole arbitrator, the matter shall be referred to the person designated by such ED&R in this case, who was willing to act as sole arbitrator, and if none of them is able to act as an arbitrator, no other person should act as an arbitrator. The appointment of Director Marketing or his nominee as a sole arbitrator by the corporation cannot be sustained. If the office of ED&R ceased to exist in the corporation and the parties were unable to reach to any agreed solution, the arbitration clause did not survive and has to be treated as having worked its course. According to the arbitration clause, sole arbitrator would be ED&R or his nominee and nobody else. In the circumstances, it was not open to either of the parties to unilaterally appoint any arbitrator for resolution of the disputes. Section 11(6)(c), 13 and 15 of the 1996 Act have no application in light of the reasons indicated. In view of this matter, the impugned order dated 8/11/2006 has to be set aside and it is set aside. The appointment of respondent 3 as sole arbitrator to adjudicate dispute between parties is also set aside. The proceedings, if any, carried out by the arbitrator are declared to be of no legal consequence. It will be open to the contractor and the Yes, ma'am.
The opposite decision clearly says.
I'll skip the entire thing, because various Supreme Court judges have referred directly to para 52, page 130.
Yes.
Mr. Sundaram has strongly relied on Pratap Chand Nopaji. In the said case, the three-judge bench applied the maximum Q facet per alium facet per se we may profitably reproduce the passage. The principle which would apply if the objects are struck by section 23 of the Contract Act is embodied in the maxim quid facit per se, alien quid facit per alien facit per se, which means what one does to another is done by oneself. To put it in another form, that which cannot be done directly may not be done indirectly by engaging another outside the prohibited area to do the illegal acts within the prohibited area. It is immaterial whether for the doing of such an illegal act, the agent employed is given the wider powers or authority of the Adapia, or as the High Court has held, he is clothed with the powers of an ordinary commission agent only. Therefore, said authorities have been commended to us to establish the proposition that if the nomination of an arbitrator by an ineligible arbitrator is allowed, it would tantamount to carrying on the proceedings of arbitration by consent. According to the learned counsel for the appellant, ineligibility strikes at the root of his power to arbitrate or get it arbitrated upon trial nominee. In such a context, the fulcrum of the controversy would be, can an ineligible arbitrator like the managing director nominate an arbitrator who may be otherwise eligible and a respectable person? As stated earlier, we are neither concerned with the objectivity nor the individual respectability. We are only concerned with the authority or the power of the managing director. Because they're dealing with the facts, my lord, in this present case, it was the managing director or the committee which was interviewed. By our analysis, we are obligated to arrive at the conclusion that once the arbitrator has become ineligible by operation of law, he cannot nominate another as an arbitrator. The arbitrator becomes ineligible as per prescription contained in section 12(5) of the Act. It is inconceivable in law that person who is statutorily ineligible can nominate a person. Needless to say, once the infrastructure collapses, the superstructure is bound to collapse. One cannot have a building without the plinth. Or to put it differently, once the identity of the managing director, sole arbitrator is lost, the power to nominate somebody else as an arbitrator is obliterated. Therefore, the view expressed by the High Court is not sustainable, and we say so. Another fact needs to be addressed. The designated judge in a cryptic manner has ruled, after noting that petitioner had no reservation for nomination of the nominated arbitrator, and further taking note of the fact that there has been a disclosure that he has exercised the power under section 11(6) of the Act. We are impelled to think that that is not the right procedure to be adopted, and therefore we are unable to agree with the High Court on that score also, and accordingly we set aside the order appointing the arbitrator. Next, my lord, Perkins Eastman, my lord, 132 page number, another judgment. Let me just read the first few lines itself, my lord, which are the summary. Yes. Appointment of an arbitrator by a party, official, authority having interest in the dispute or outcome, impossibility thereof, independence and impartiality of arbitrator, necessity of. So the impartiality of the arbitrator, my lord, is of paramount importance, which is why the Act mandates, my lord, that if the other party does not respond to an arbitration notice or is not agreeing to the appointment of the arbitrator appointed by one of the party, when it's a sole arbitrator, then the only recourse according to law, my lord, is that there has to be an application under section 11(6), whereby this honorable court, my lord, has to appoint the arbitrator under section 11(6) because of the need for impartiality. Yes. Para 24, my lord, okay. Page 154. My lord, and only 4 lines I just read, my lord. Para 24, my lord, at page 154.
Yes, ma'am.
My lord, they have extracted again, my lord, the independence and impartiality requirement, my lord. The dominant purpose of appointing an arbitrator or arbitrators is the impartial resolution of the dispute between the parties in accordance with the terms of the agreement. And although the contract between the parties and arbitrators would be a contract for the provision of personal services, they were not personal services directed to the parties. 21, they have extracted under paragraph 21. Similarly, an independent hand is indispensable in exercise of judicial power, whatever the source of that power may be, and it is one of the essential qualities of an arbitrator. Only one para, which I extracted under section under paragraph 26, next page 155. Unless the appointment of the arbitrator is especially valid and such appointment satisfies the court exercising jurisdiction under section 11(6) of the Arbitration Act, acceptance of such appointment as a fait accompli to debar the jurisdiction under section 11(6) cannot be countenanced in law. In the present case, the agreed upon procedure between the party contemplated the appointment of the arbitrator by the second party within 30 days of the receipt of the notice from the first party. While a decision that switch days may be introduced, some flexibility in time frame.
Yes, ma'am.
Agreed upon.
Result, please.
Para 31 also, my lord, been working.
That's the problem.
Appointment of arbitrator. These ground have 34 applications for the district court. And actually kindly see the page 26. These are the arbitrator, sole arbitrator appointed in section 10 up to subclass 2 of arbitration conciliation as in a district judge session judge retired person of district judge, judicial officer. Actually, these judgments are actually which only favors the company, respondent company. Actually, moreover, the appellant has not had such things before the under section 34 of the arbitration appeal. And also this 37 application also there's only this the proof of rule. It's not taken this 29A or else saying that arbitration is illegal. Himself denies the notices of the arbitrator. He himself not participated in the arbitration proceedings. He set ex parte there. What was passed? He preferred appeal. Appeal was dismissed only saying that it is same thing. He has to be saying the 34 application.
With appeal copy.
Kindly see the judgment district order, appeal order, page 12. Page 12. Page 12. Yes. Arbitrator and against the national as per the rule, he cleared there. Clear to say that interest cannot be the principal immunity. In this case, it is the law of the documents based to set aside the award taken for solution case by remanding back to the matter to respondent by giving the opportunity to contest the matter. Hence, try to set aside awarding arbitration case passed by arbitration. Remind back the matter to say so again giving the opportunity to minister to contest the matter. Both the years earlier the both respondents main ground argued by the petitioner assailing the included order of first respondent petitioner paid 2,69,000. So leaving the principal amount of 1 lakh, the petitioner is examined PW1 and he stated that he paid with an accident sustained head has paid huge expenditure for his treatment. As such, he could not repay the remaining of the years. PW further stated that while receiving the monthly installment excess amount has been collected mentioned in the claim petition before the sole arbitrator and the arbitrator of the ledger also shows the same. And responding to the calculated the interest also interest of the person. The sole arbitrator is not sent any notice to him before passing the award in the arbitration case, which needs to set a PW states that you owe the sum of 1 lakh only for respondent 1 lakh, falsely claiming the amount of 5 lakhs and sole arbitrator wrongly passed the award 5 lakhs together with the interest of 2 lakhs. As per the rule, interest cannot exceed the principal amount, hence pays to settle the award. Law relating to the reports the court against the awards made with the arbitrator is provided under section 34 of the Act. When the arbitration award will be set aside by the court only when the party making an application furnishing a proof of to the effect that party was under some incapacity or the arbitration agreement is not valid under the law to which the parties be subjected or any indication thereof under the law. For the time being in force, and the party making the application was not given proof proper notice of the appointment of the arbitrator or the arbitrator proceedings or was otherwise unable to present this case, but there is a petitioner entered into a valid agreement with the respondent number 1. Petitioner was given a proper notice on 16/3/2016, admitted that the petitioner did not contest the case before the arbitrator. It is clearly petitioner that failed to furnish the proof. He has not needed anything such in that section 34. 37 the arbitration section also clearly says they cannot say the new grounds here. Also, there is no ground to say that arbitration is illegal. But also, my arbitrator was district judge, but the judgment also only says clearly. Ferguson also says clearly who is a favor to the section 10 of arbitration and conciliation. Who is the employee or else favor the company. That is the only thing. The district from the judicial district retired district judge was appointed under section 10 of clause 2 of arbitration. There also the appellate reason agreed to the appoint the sole arbitrator. There is agreement clause. He made agreement to appoint the sole arbitrator. And when arbitrator issued a notice to appear before the petition, he denies the notices and the
Yes.
This play has to be taken in section 34. If it is so.
Yes. Yes, madam. That's right.
Since 1955, financing and other. Then my lord, the meaning of jurisdiction.
You have another copy, is it, with you? You have another copy?
Financing my lord, constitutional bench judgment, my lord. Consistently held, my lord. Page number 61, very short judgment, my lord. Very succinctly and clearly. 61.
Yes.
6, my lord. 4 lines from the top. It is a fundamental principle well established that a decree passed by a court without jurisdiction is a nullity. That its invalidity could be set up whenever and wherever it is not to be enforced or relied upon, even at the stage of execution and even in collateral proceedings. A defect of jurisdiction, whether it is pecuniary or territorial, or whether it is in respect of subject matter of the action, strikes at the very authority of the court to pass a decree, and such a defect cannot be cured even by consent of parties. Constitutional judgment of future. I'll give copies now immediately in 10 minutes. Subsequent judgments, 5 judgments has continued in other land. Till recently, also Supreme Court has consistently been following this judgment. My lord, there is no diversion from this fundamental principle of law which we have been accepting since 1955. My lord, it's an establishment of law in the country. Hence, my lord, even by consent, even assuming that the argument that I have ever consented to appointment of such person and deal with the arbitration passes to one. Where there is a lack of jurisdiction, the appointment itself is contrary to the act. My lord, the appointment of arbitrator has the feature of the contract and of the act, the statutory creation. Therefore, my lord, all the powers derived by the arbitrator are only derived from the statute. And if the appointment itself is contrary to the statute, which it is under section 11(6) of the Arbitration Act, then such appointment, my lord, is illegal. And it does not have to say that I have requested by consent that the arbitrator appointment is valid and the award passed is legal.
Yes. Here it was. Both orders after 3 weeks. Okay. Yes.
Since the interim orders passed, my lord. My lord, despite the order passed by this honorable court in EB proceedings, my lord, the EB court has passed an order on 12th of October, my lord, directing the salary accounts, my lord, to be attached.
It's
on 11, my lord, and interim order till then, since then it is not been listed, my lord, even on the day it was not listed. On the Supreme Court has
Here are the copies.
I will just tell you.
Item number 20. G. Mallikarjuna and Govind Reddy.
Your Lordships, I am appearing in this matter for respondent number 1, that is Preka Solutions. Your Lordships, we have already filed a counter in this matter and we have also filed stay vacate petition. However, Your Lordships, this stay vacate petition has been returned with some office objections regarding service of notice on respondent number 2, that is SRR projects. I would like to report to the bench that we have issued a personal notice to SRR because till now there is no advocate on record on behalf of respondent number 2, Your Lordships.
Okay. Most probably. 6 times 2. You should come the file number 2. Most after 4 weeks. Yes, sir.
Item number 21. P. Krishna Reddy.
Concentration for the 4 weeks.
Item number 22. M. Srikanth. D. Dhananjaya.
documented.
The last occasion matter was adjourned for bring on the elder of. This is petitioner. What happened? Who's the petitioners? Who are the petitioners? Srikanth. Yes, sir. What happened? Spot number 1. Yes, sir. Actually, the spot petition company. Spot number. Spot number expired.
Expired. You were very long by that.
No, sir. There is no adult petition number. Verify with registry. Whether it is written or not, we don't know. Actually, we have to file adult petition. Huh? But they do not know particular. They want to file adult. Because for right, sir. Also, petitioner seeks time. Post after 4 weeks. 2 weeks. Print the. You have to file the adult petition. Version not appearing for the correspondence. Yes, sir. Budget. Give the name of source. With the budget, file the name of source. 2 weeks.
Item number 23, J. Kankaya, Alvin Partners.
Finally, when the issue of this petition is
Final limits okay. 7 and 6, 6 years, 7 years.
6 years.
Okay.
The layout was very, very backward. So I have filed my neighbors' plots also, where they show my boundary. I have put their dimensions also in the name copy. The actual layout I have filed. Some and I have.
Sir, petition cost has serial cost has limit something, sir. Wait.
The point is,
Wait, sir. Wait. Either petition cost.
Number 39, where the wave number 4 in that will actually be respondent hearing are taken by the page number 40 para number 2 and receiving command from this source the defendant filed written statement on brief government of the written statement or that defendant government who are advised and they denied the allegation of the plaintiff and the plaintiff never purchased the property now with portion of the defendant further submitted defendant number 1 have purchased the plot bearing number 60.
Yes.
This is the spot taken by them. But will have to pay the suit was declared in government. Again, is that not will have to the report and appeal. Even in the appeal also made contact the case I would get. Again, is that not the report second. Second appeal withdraw. Now they find the present suit claiming that 68, the plot subject plot is 68, they are not supposed to interfere, that is the fact. I can add to the best of my knowledge and my experience. If the second appeal is allowed on this piece, they have to prefer the SLP by establishing that the subject property is not 6 and 68 because the start is right from the beginning. But they did not do so. And now they have found that once again, this then land of, the plot of 16. And well, I will kindly look into my land friend and finally I find the document kindly look into that.
Dated. Don't find it, sir.
But I find it the last thing. Even
last time. Before vacation, sir. This is sir.
yes, yes, sir. I like to kindly look into that. 1, 2, 3, 4, 5, 6, 7, 8. This is the serial number. Level. Yes, Lordship. Right side. 1 and 2, that is the star. 1 and 2. 1 is visible. That will actually kindly look into this. One. One, two, three, 4, 5, 6. Part number 1, Virat. There is one, sir. May I go? The red mark is there. The red mark is there, sir. I understand. 1 and 2 is there. 2, 4, 5, 6. 6. Marker 6. Yes, sir. I mark. Right side 4. Where is 5? 7 and 5. 4 and 5 is there. 7 is there. 7 is there. Where is the 5 and 5 and 6 is there? 9. 9, 7. The numbers are what they have given. First number, second, third, fourth. Okay. Like that. 1, 2, 3, 4, 5, 6, 7, 8. Yes, yes. So this is the layout plan. Whether it was the approved layout, but it was subsequently LRS, whatever it may be, because they have constructed. Now the question that my management tried the layout plan. I mean, the page number kindly look into that. Dated memo. Layout. That is the last. The management find the material paper. Dated. Dated. September 26th September 23rd September. 6th September 23. 6th September, yes, sir. There minute, can you page number 10 minutes? Page number 10. 10. Page number 10 is Vijayawada Semi Namak, second appeal. The documents filed by 68, sir, on 6th September, judgment memo second appeal, copy of charge sheet, FIR, copy of photographs taken 6A, photograph of 6A the attack. That is the next study. There are 3 received documents. 3 received. 3 received. IA number, this is IA number 2. IA 3 is IA 3. IA 1, IA 2. Where is 3, sir? He submitted the layout. IA 3 was not printed up by the registry, sir. Only IA 1 and 2. It should be written actually. Doesn't get those for filing second shoot. Once he contested. No, last occasion about virtual judgment. He has taken the time filing of the judgment as mentioned, sir. IA 2, IA 1 they file. IA 2 judgment. Yasho Sod versus Kirti Pradeep Sud. Yes. IA 1. That is IA 1. IA 1. Then with the list with my neighbor plots. No. IA 2 is charge sheet FIR and photographs taken 6A. Photograph after attack. Yes, sir. That is. So this is IA 1. IA 2. Sale deeds. With sale deeds. My neighbor sale deeds. IA 1 along with sale deeds. IA 1 that is. IA 2 is. With the judgment. The judgment to my withdrawal memo, which clearly says that 6 and 6 photograph and photographs of the plot, yes. Where are you? What about IA 3? IA 3 is the one with the layout. Numbers are number 89043. IA 3. Yes, this is IA. I understand the plan. That quality. That is the interesting. This is my Wi-Fi aspect. I see. The layout what he has to do. Same layout. In which period you are plot number 1? It is not visible. Both the layouts are not visible, but that is my problem. How to take?
These are not registered levels.
What is the judgment of Supreme Court?
With regard to the category.
Yes, sir. Para 4, sir.
Yes, madam. After having but the land council applying for the party, we find that the fee of the regime data could not consider and gone into the application made by the applicant under rule 11 and order 7. Apart from that, order 11 rule, that you order rule 11 and order 7 kindly will be taken. The issue involved both the parties one and the same. And the issue was denied by the respondent.
Sir, para 6, sir. Para 6, green, para 6.
Yes, sir. Hence, in our view, the issue of regime data could not have been decided an application at the level of the shop. The reason that the adjudication issue involves cancellation of the pleadings in the executive, the judgment of the trial court and judgment of the appellate court. Therefore, we make it clear that neither the learned syndicate nor the division bench at this stage would have decided the issue of regime data raised by the appellant on merits. Therefore, we agree with the final conclusion of the division bench of the High Court that the suit needs to be decided on merits with the context that here in our case, the question that the reasoning given by the Honorable Supreme Court that with regard to the same plot claiming by them is not discussed. They have contested that
the issue of reciprocator could not be decided on application under rule 11.
Yes.
Order 7.
Yes.
What the meaning?
You like to check that.
There only one. Unless is reciprocator only. The order of application.
Here.
So it applies the judgment. I will agree. Yes, sir. Yes. And 4 factor. 2 weeks, sir. I will post 2 weeks.
Much of that.
Contract 26 and for 2 weeks. Yes, sir. This is not contract. No problem. But 2 weeks. You are
Item number 24 is request of the Venkatreddy.
yes.
So they can on notice of number 1 is for R5. The notices were returned. Loss of R5, the notices were returned. File the proof of service. For R7 it was covered.
In this matter, we take this for R15, 16, and 17 matters who are the legal heirs of the number 5. Take notice of the same matters. It may be recorded as Mahathiri has taken notice of the same. But I request matter may be taken up after 23rd matters because respondent number 16 and 17 are residing in US. We'll make arrangements to get the wakala. In the meantime, request matter be taken up after 23rd. We'll file wakalas for respondent number 15, 16, and 17.
Post plus part 6. Post after 4 weeks. Yes, sir. Yes, 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 sir. 4 weeks.
Item 21 agenda. Item number 26 is KV
Tomorrow password for what is this matter? Yes. The passes. Possible.
Item number 27. Yes, Pritika.
It is petition for expert opinion for case on the ground of unavailability of part of the. And on the ground that I have not mentioned the SIP which have been sought to be complained. In fact, Millard, we have clearly mentioned in my claim that we have filed a document. These are the receipts which have been executed by the dependent number one. With the agreement of sale. Agreement of sale. Agreement of sale. Thereafter, receipts are passed on by the dependent number one. That is receipt for exhibit 4 to 6. As part for the comparison of the signature of the dependent number. Along with this certified copies and color next. That both below come to a conclusion that page number 10.
Yes, sir.
Now, only when exhibit 10 and 11 are certified copies, they are not. But there is an exhibit 11 blood availability of document is there. We will file the original document. No harm which is caused when the let court come to the conclusion that without sending the document, court come to the conclusion that these documents are uncomparable. The incomparability of the document can be decided by the expert.
No, sir, for the Wakalat and Risham taken account, not taken account.
Yes, I know that. Exhibit 10 and 11 are the sale deeds executed by the dependent number one. What happened? Plaintiff and two brothers are entered into agreement with D1's agent. Plaintiff have executed sale deed in favor of the brother of the plaintiff.
Sir, you want only to order prayer, you want to order to segregation of the Wakalatnama, segregation of the settlement. And after
Exhibit 10 and 11 are the certified copies. We are ready to file the exhibit 11 original copy, which containing the contemporary signature 1992. The sale deed executed by the in the lower court only we have filed a certificate copy because the document is pertaining to my brother's file. Now she has handed over the document last occasion we have said. It is the same argument before the earlier it was reserved for orders and reopened. The document also filed before the document. Now we are having original document exhibit level containing the signature of the dependent number one. Right. And if it is said no harm will be caused with that. Let court will come to a wrong conclusion that these receipts are part mentioned by me. In fact, my case itself will page number 18. My page number 18. Kindly go through page number 18. There the bottom line. The agreement of page number 18. The agreement of sale and receipt of foreign agreement. They may be read as part and the parts of this. Let court will in this order. Kindly go through page number 10 of the order. Third paragraph. Exhibit 4 are these issues rightly argued by the Land Council for Defense. Nowhere in the claim petitioner mentioned about the exhibit 4 to 6. But they came to conclusion that I have not at all mentioned it. In fact, I have mentioned the plate. I filed around the plate also. Please read. I am relying on this document by agreement and agreement of sale. The dependent number one passed on receipt exhibit 4 to 7. This is my case from the beginning. The plate along with the plate I filed in receipt. In fact, when I not introduced these documents, in fact, after my examination, dependent upon our past action, the first. Then we have filed a petition for send these documents for expert. But merely because there is non-availability of contemporary document, it cannot be started minute. For expert. Now, exhibit 11
document number 102 is available, my lord.
Yes, where is the document?
Just find a copy, my lord. A copy of it. Last date of keeping in file, then that was after filing the document, it was for result for orders. Thereafter, the alien not was ordered. Yes, sir. If you get the case, result for orders alien. But from the general, I provided opportunity with the document. 56,992. Document dated 56,992. Yes, yes. 1092 of 99. That is executed by different number. This original document is there. It is a contemporaneous pieces from the year 1990. So I want to produce it. I will produce it. Document. My interest might be protected.
Already exhibited.
Yes, it is certificate copy is marked. Because this is a certificate copy, only one signature is that a certificate copy. Error might can exhibit 10 and 11 are the certificate copy are shaded by document number 1953 of 92, 1021 of 92. As two documents are certificate copies, the edit signature dependent. The certificate copies cannot be sent for comparison.
So what is the document number, sir?
1021 of 92.
Document number 955 1990.
What is two documents? Two documents. I will file a document.
So the document is not an exhibit A11, sir. This is 9. This document 955, not 963 or 1092. 1021.
1021.
Yes, sir.
I will file it.
He filed a super declaration of title and perpetual injunction by way of adverse possession. That is the suit he has filed.
Yes.
He filed now the present petition under section 45 Evidence Act and for expert opinions. The stage of argument. Case is posted for argument. At that stage, he filed his application. And that application he filed Akalatnama, written statement.
Yes, sir.
Exhibit A4 to A7.
Rightly dismissed by the.
Yes, sir.
Yes, right.
That is the FIR. In the FIR, no signature is.
So we want to produce some other document.
I want to find that documents will not be now my is relying on the document. 92 documents.
So this is
the 14 suit is filed in the year 2014. 14 or 13.
13.
Then that 8 years and the 13 years. So the last is not the contemporary signatures.
No, contemporary signatures.
Yes, but 92 minutes is the 14.
No. Now, subsequent after filing of CRP, you want to rely on other document, sir. You want other document.
How can it be filed another document? It is open for he can file an application before the trial court. Actually, put this court.
Yes, you want to. That should be the court below.
If the law permits period, he can file any applications. I cannot prevent by filing an application.
961, this is not 963. That's the petition before the court below, sir. You want, well, I'm limited to file. Yes, permitted to file. No other documents. They had, but not by 96.
The present order is no illegality.
Not 6 after 4 weeks.
The law permits.
After 4 weeks, 4 weeks. Yes, sir. Let's call the next case. No, sir, 4 weeks.
I contact is
over the case is over, sir. Our area. Next case, call the next case. 4 weeks. Make no difference.
Arbitration.
Already is there, sir.
Oh, is there.
Till the pronouncement of judgment,
No,
direction.
what happened? They are not a.
Okay, your case. Excellent, sir. Okay, your case. Postmortem 4 weeks. In there. Yes, sir. sir, 193, 19, 10, 20. Already, yes, sir,
This is third time the same address which is published in KV filed by the respondent. Return the marriage.
No. It was not there. 1910. Marpota by the registry. 1910 means proper today. Yes, sir, the Marpota by the registry. What are the numbers, sir? Respond, how many numbers? Respond.
Four members.
4 to 7 only. 3 to 1 to 3. Appearing. Government. Then take steps for the publication, sir.
The address is published by the aviator. The themselves when this KVS petition I sent and someone for vehicle fraud and last time also. So it is return from
First of all, not answer, sir. Then problem. Also, the attachment of the covers. This is related to something. Yes, sir. What is your number, sir? Also, post on the no, yes, sir. Number. Then a clerk was ratified. This
action is there. Yes, sir, I will verify. Okay, because
I'll put her 2 weeks. Take confirmation. Put her 2 weeks. Yes. Right.
Item number 29, G. Praveen Kumar, yes, Jagdish.
Yes, sir. Yes. Ready? The last 2 times you are not a friend. 6, 9 and 4, 10. Okay. Cover part 6, 10. Post of 5 living after 4 weeks. Already accepted and the last. Yes.
Item number 30, CV Chaitanya, Ravinder Reddy.
Last second, before vacation, argue the matter. We want time for 1 week. Quite covered matter.
Check the
Yes.
citation.
Matter exact. No, madam. See, and argue share to argue the matter. After that, transfer. It is the 6 10. Post after 2 weeks.
Next week.
2 weeks.
Stay is there.
After 2 weeks, we'll see, madam. That's possible.
Item number 31, please read.
OS 99
The respondent defendant filed an application on a policy to 17 matter. Written statement to amend the written statement. In fact, is a suit for injection syphilis. He says that he validated the part of the schedule not along with the vendor.
Validated 22nd June 2022. What is the stage of solution?
We have the deficiency evidence, my lord. The evidence, creative evidence is completed, my lord. Now, the time of.
So you have not passed the matter since last 1 year, 2 months or 3 months. You filed only CRP filed on 26/8/2022. 26/2022.
Objection, my lord.
No further petitioners. That is the enactment. Subsequently, now today, first time, after 1 year, 3 months.
Objection or not.
It become infectious this CRP.
In fact, see, the issue is, my lord, seasonal injections is around, my lord. But page 7, my lord,
Don't respond, sir. Don't respond, sir. Master, please, take up for 4 weeks. No, sir. Take out, don't respond, sir, for 4 weeks.
Item number 32.
Yes. That's the one. Last occasion. Yes, HIGHCOURT. There is no intensity as per okay, sir, give one more chance, sir. First for the petitioner seeks 10. Post after 2 weeks.
Item number 33. D. Chanakya.
There are quite top service. Yes. Sir, 5,000 written documents, written the notice. 9-1. Last service of notice to the respondent, sir. Written cover. What is the attachment? That's in depth. Yes, sir. Appeal still want to file issue documents.
The state that the application of the order for should be decided in the final hearing of that. You have to after the party appears, submitted for finalizing not to the application of the order for should not be decided before the party has concluded their argument in the case, except in the exception circumstances in case where the case of the record application for additional evidence is not given. Before final hearing, the applicant cannot form an opinion whether a document should be admitted to evidence for request and to be examined. And therefore, the application for additional evidence should be normally indicated at the final hearing in the case. In Union of India was declined to be reported in the Supreme Court as observed as order body. The application of the order body is considered at the time of hearing to correct on the base as to find out whether documents or evidence to be admitted have any relevance bearing on issues. Possibility of additional evidence does not depend upon the relevant issues of the fact whether the applicant had an opportunity to it depends upon whether or not the applicant is required evidence must be admitted to the of the issue of the substantive form. The group is therefore whether the applicant was able to pronounce the evidence for material without taking into consideration the additional evidence. So occasion to arise only for examining the evidence and the court comes to the conclusion from evidence that it becomes apparent. It is pre-judgment. Immediately the order should come to the application. Now the appeal is pending, IJ is passed, the application is dismissed. And there is nothing on the Lordship case, they are moving back. Lordship case, they say that they are latched. But ideally the threshold of the test is whether that is required to prolong the judgment in the appeal or not. And finally the finding. Therefore, the idea
Session dismiss along with the appeal. What is the meaning? You want to dismiss that? Like, I'll dismiss by I have dismissed. Now you want to only dismiss the idea along with the final the judgment and decree.
Opinion has to be expressed in the appeal, not either this way or that. But not at the appeal is pending, not in the interrogatory order. Because then it becomes.
Then take out respondents in the court below, sir. First for respondent in court below. Not I can notice the first for respondent. Take notice the cost of appealing the respondents in the court below. First for petitioner to take out the respondents as well as cost of appealing for the respondents in the court below. Post after 4 weeks. 4 weeks.
In that case, the application is paid.
Take next item. Yes.
Item number 34, police reason of
Yes, sir. You should follow the dependent court letter. Put for injection. The order 9 movement was allowed by the order. Budget idea is filed by the rating not bedroom this was for dismissal for department. Subsequently, he got entered the dependent entered into the suit property. Therefore, the suit for injection. Next. The suit was dismissed for department. Immediately after the dismissal department, the dependent entered the suit property. Therefore, the last in the position. The main suit in effect become infractions. Subsequently, find the higher find not maintained. This is my contention. One more contention, one more contention statement. He not shown any cause for not appealing for the post below. Therefore, they file a medical certificate in which will not this for dismissal for department December. Wherein the greatly show that his father not well, therefore they could not appear before the court, and the advocate also not appeared before the court. But in your last candidate page 52, his father appeared on 30th March 2021 and discharged on 31 May 2020. This suit is for departed in the month of December.
December?
Suit for the month of December.
Yes, sir, I want.
21.
December 2021.
There is a 7 months delay. Thereafter, they filed after this is for default. They filed a distribution petition Meanwhile, the dependent already entered into the suit property and renewed property. The way filing of suit itself is a become infectious.
Injection suit, what date of the day? Take into account of the date of filing of suit, not for the disposal of suits. Well, deciding the injection suit, take into account of the date of the setting up, who is the question of the property on the date of the filing of suit.
That is my condition. Claiming the filing position.
Yes.
Therefore, they find it.
But admission after disposal of the suit, they have entered the
Yes, sir.
property. What is the meaning? Control the property. Parallel relation under. Then
There is no intention. There is no intention.
no, sir. Date of filing of suit, you are not the property. You are admitting that.
That is the condition. Can be considered. That is the condition of the plaintiff. They are in the position of the property. Thereafter, the suit for deferred. Thereafter, as per my defendants will have your last candidate written statement clearly stated they are in position.
Why are you saying that already after integrated entered the position of the property? Family commission. Even after disposal of suit only you are entered the property. That is what.
Even assuming that last in position. Even last in position. When last in position,
When the last in position, sir. He claiming that in position of the property. You are also claiming the position of property.
I am not admitted. Come to page number 48. I am not admitted because they are in position. My page number 48.
One minute, sir. Yes, sir.
I am not admitted that. In written statement, it clearly states that I am a purchaser, I am registered purchaser, I am in position since purchase of the property, I am in position. But whereas the plaintiffs alleging that they are in position, they are access to property, they are in position. But we have purchased the property from their ancestors, we have under registered sale deeds. Since then we are in position.
Before registration of the suit also are in the position of property.
Even assuming that for deferred, they are in not position. Since 1 month they are in position. Therefore, they made Indian suit itself become infectious.
That is not. Yes, sir.
I not
delay. How many days delay? There is no delay. There is no delay. Then they can file.
But you actually come to the written statement at page number 45. This statement filed by the petitioner. My friend said he will question the property.
Yes, sir.
That is a written statement filed by the suit. Yes. Then Rashmi comes to page number 48. Counter claim filed by the defendant. And your Rashmi go to page 55. Declared the plaintiff of absolute owner, that a respondent disbanded the illegal system control further direct the respondent delivered the vacant question property. They themselves are admitting I'm in possession of property. They are seeking for restitution by way of a counter claim. And my friend says that he's in possession. He's in content is what it is. Yes. I'm not coming to this lost traffic. Lost says counsel or I know that there's no dispute about it. And the lost takes the affidavit filed at page number 20. Page number 20. 22 is the affidavit. Lakshmi come to page 23, paragraph 5. This is the affidavit. I submit that we are consequences for with the argument that for past 3 years, there was several instances and was admitted to problem 31 weeks and for 61 days, only discharge 31 5 and post discharge continued with gratitude completely. And further, due to the results of the piece of only such was take care of the any father had take care of the state not attend the office. Further, the father is also better. As submitted where on 22/11/20, counsel was informed by one of the Madam Kumar the informed that this takes time. And basing upon such request made a colleague of the counsel, counsel checked for please to attend matter. According to said after was coming to pass by the however, due to the counsel taking care of work, unable to attend the office regularly, he could not neither prepare the private nor could inspect the water effect sort of action. As there was no replacement. So it's because of the only and you also notice this is the time when phase 2 of the COVID was going to happen. Not every matter was being taken. Phase 2 of the COVID. Yes. And subsequent the learner takes note of this fact. The father of the council died. That's also taken note by the learner. Yes.
Page 11.
Yes. But page 14. Page 15. Literature talks about this issues. Yes. And then para J, it deals with the sufficient cost. Number today, already chief is filed and it's from the process on. The issue is whether health of water and 61 days in hospital, then dialysis, and subsequently passed the water pillar and then they said passed it in December. One, only in the capital, he was taking our father. He is not attend the home. Second is during this period, but there was a phase 2 of the COVID restriction. And it's supposed to be no rest. No policy orders could have been passed. Third, so more the change one. PSP have been taken up. But after 28 February 2020, yes, 28, this all happened during this period. The learned judge said this is sufficient reason. Allowed the chief is filing from the process. There is CIP and it is food for injection because I am in question problem. So restraint from the themselves by the written statement. Today my friend is saying that subsequent to this they are taken to it. That means illegal has been complete. Illegal has been complete. Even that has been sent to the learned judge. That's what come to. Para number. Page 14, para H. So far, the pandemic learning costs were responded. The subsequent dismissal question of the schedule was taken out of the respondent. Therefore, the simple super is not relevant. In the case of some person, it's held in such circumstances, the order 627 of conferred jurisdiction of the court provides other party to order government to change any state. Thus, it is held that the institute sufficient parties for the to avoid multiple. This is the amount extra. Now, but first of all, you are assuming that taking personal property. Still, is the permission. Yeah, the Rashba right is that the injunction has decided is having the date of filing. Other than that, the other lines. That's the issue. Today, the answer for written statement is happening. Today, during the month of take a 527, this was still I'm interested in get the food restored. Yes, restored. Because I can read evidence and prove that as the date of filing of food. But if I please expose this, my review having by section 6 also. Yes. Therefore, the learned judge was read it, and then now you also notice the order of it. Order dated 27th October 2020. This is on subsequently much water has come to keep it. Going to what I know, it is being first. Going to what in this matter? No, it is being first. Now they have to tell me what is it being first. Except saying that I have taken out the question after dismissal of suit. That is not a ground for. So yes, there are. Yes, there.
From the after to where nobody prevented her.
The council advocates are mistaken advocate not by the party. This matter. Party, not party. Not council. Council father expired. He was unable to attend the court. That's the only issue. We also take number of time for the judgments. Father of the council. Father of the council.
Dismissal default. Before, not before.
Giant asked for 61 days in hospital. Yes, already within time. Already within time. There is no delay. And Norma said, yes, there is no delay.
Once the injection, this is for default. When the portion taken by the defendant,
no, sir. Means you're not going to have that of the
no injection granted by the trial court. There is no intention at all. If they,
Who only decided on the date of filing of suit, not by the date of the dismissal, sir. Frequently, it's on file for express in this occasion. Yes,
I'm questioning that restoration itself might be restored.
So the right is clear according to injection application there. That was discussed in how it is maintained level. Under this code, that injection is maintained even though before it is suit is restored. Relying upon judgment of Assam High Court. These judgments have passed on. Post orders. After 2 weeks of the judgment.
Wait this one. Wait some cases.
Okay, post order of 3 weeks. Yeah, go sets post order of 3 weeks.
Item number 35.
Argued Mary's responded. The order of the law for it's been primarily US answer. Okay, we have one of the boss defense by different point. While you're not dictating order, you also notice that the name. Yes, sir. Moreover, I will also. On the condition of the right with right with this is the petition respondent, sir. Both are dependent. Say they are saying that both are colluded with the Asha saying that federal colluded with the other side. Both of us actively sue for specific performance. And whoever is in position doesn't even matter. Where is the sir? Where is the back? 10, 8, 16, 10 minutes. 6, 10. 6, 10. HUR Gopal. Person to HUR Gopal, senior counsel. Yes. Is the counsel report. Also, counsel can report the respondent 4. Special service the first part. Almost 1 year, 1 month over. Post after. That's part number 4.
Item 36, 37, and item number 38, affirmation.
So the conflict at 4 weeks.
Item number 39 and 43, considered. B. Sudhakar Reddy, and the law counsel.
Yes, sir. Ready?
We discovered that there is an unstable application and to grant an injunction against that. Who's going to have to file? So we discovered it rapidly last time. And only had 2 weeks time to file some. 3 days IS7.
Yes.
IS6 is done.
We respond 58, 61 now to include.
Yes.
Only number IA number 6 and 7.
Okay.
IA 6 is included and IA 7 is for the injection. Restrain the respondent, propose the respondent number 58 to 61.
For the employee is concerned, order notice, also personal notice.
Yes, sir.
For the redemption handling is concerned, passing an order, because up to 29/6 I had a state notice. 29/6 unfortunately, there was no representation, stay was. But the present respondents will not be affected, but it will come there. And it is already enough litigation from 1979. That I think my late further HB products were only the creative situations. Date we fixed that we are ready for the argument.
Sir, they are not pending the respondent number. Included respondent, not the respondent. Only the prayer for the IA number 6 prayer is the direct just and respond proposed respondent number 58 to 61 from eliminating, transferring, conveying the petition to property to third party or stating any interest. That is only prayer.
But these people are transferred. That gentleman again transfer.
Yes, sir.
Again, I will have.
You have no interest in it. You already transferred the property. You have no interest in this property.
Interest, I'm very much there. Lost. This is a 21 CAD. We also run through it. We will file a comprehensive counter to it. If there is not any shorter date, may be given. File a only day before a state possible. Some opportunity will file a counter.
Also, response 6 well counters IA number 677 223 post after 2 weeks.
Personal notice.
Okay, the IA number 7 post for the take of the respond number 677. Okay. There are portion 4 weeks, sir.
Because the person who received the notice obviously will come and take. But
no, immediately we don't know whether that is 4 weeks. IA 677 for the response.
it will be second TRP. It is only 4.
6 and 7, 40 and 40 400.
At least they observe that.
It was already divided in travel.
Anyway, would take care of all the situations. CRP itself would have
Yes, sir. Pending suit already.
Right.
Item 41 engine, item number 42.
Matter and subdivision petition. Last occasion, check whether after that this is so that there is a misleading building that is traveling. It is only the mistake of the clients that they did not file No.30 affidavit. And I have actually identified this because the already said this because of the advocates in during COVID, they could not file them in time, and because of that, they have lost the opportunity to file No.30 affidavit. Page number 13.
Yes, sir.
The page number 13, it was identified there are only 2 things. One, they did not file the original will deed, and 2, they did not file Rule 33 affidavit. GPA. The original Rule 33 affidavit is supposed to be filed with solicitor. They did not file it because the advocate was sick then because of COVID. They did not have any other alternative. They have represented themselves in the court and they have submitted it. That was the major fault, and they were not having any other opportunity. Now that because the present suit, because of the original will deed conduct, the registered original will deed, because of which they are having right of the property, and now in the suit of partition, they will not be able to contest at a later stage as well, because their plea was dismissed. They served on them and they did not choose to come forward. We served on their counsel as well.
Okay, also.
Yes, Manoj.
They are not filed in the block service. Okay, this is process filed.
Yes.
Sorry.
Yes. In the lower court, because there was no defendant as well, putting the said defendant, whoever have transferred the property in our name, I sent expertise, they are moving forward with the judgment. And 2811 is the judgment is what is the latest status of the case.
So not filed notice to respondent, possible response are only filed. This is sufficient for the respondent.
Yes,
served all.
they have received it. They've also informed them because we lost the ground and the great petition. Now we are
Yes, sir.
to move forward. And now it is put as an ex parte decree. They are sending. It is reserved for judgment.
We are saying that we need to file a declaration suit, sir. There is a regulating their suits.
But I have taken a step that
I file
we
separate regulating.
my limitation is expected because
My relative registered there. File a separate suit.
Lordship, in this particular thing, I came to know about the occurrence of the said deed on so and so date, that there is an existence of this suit. I have already taken that stand. When I am trying to calculate the limitation, I cross the limitation. Within 3 years of the knowledge of said suit, I should be filing it, and already the 3 years have expired because of said court. That was
2016 suit.
Yes, Madam.
But petition that 2019.
19. Immediately as soon as I came to know when the paper publication notice was given on the said address, that is when I came to know and immediately contested the said suit.
Limitation from 2020 March to 2022.
By 19 itself, the 3 years is completed.
19 is
16, 3 years from the knowledge.
not 16, 519. Okay.
I mean, I tried to counsel our client as well on the same point, but because the limitation was not there, we could not file the declaration. And this is the only remedy that I have, unless I get impleted, my right will be completely exhausted.
Okay, I will hear you, sir. Professor, post after 2 weeks, sir.
Not 2811 is the pronouncement of
2 weeks or 28 sir.
It is reserved for judgment. 2811 it is reserved for judgment.
Sir, 23 I am posting on 23rd, sir. 23rd November.
211 was the last hearing. It is their judgment caption itself. They did not pronounce it, and they have extended it by 2 more weeks. In the meanwhile, at least one reading that there is a stay.
Respondents, respondents, help of the petitioner, post after 3 weeks, research lab, populated after 2000, OS number, 500 from the next year. Yes.
Much appreciated. Order may be released today.
1 minute, 1 minute. One minute. What is this? Someone by GP holder Syed Wasim Muhammad asked. The caller is doing. Also, also, sir.
Item number 43, Sunil P. Kamsala.
My lord, I am responding to the as it pending post on 22 November.
Also got the citation.
Your Honor, the date of listing is 22 November. My only Haridas Sharma as his
relative expiry went to native place. Candidate is posted on 22 November, so on that day we didn't do that. Online it was showing that it was 22 November, Your Honor.
So we not taken to all sir. We don't know. This matter was directed 1810. Post this matter 8/11/2023.
Correct, Your Honor, but online validation it was 22/11. So
So mistake, sir. Actually, that was decision 410. Then cost for respondent 610. Posted on 1810. And 1810. Then cost for petition 610. Decision today 8/11.
22/11 was showing that.
So I will okay.
22/11.
After 2 weeks, 23/11, sir.
No,
Cost for the response 610.
22nd.
Sir, we will not give appointment to High Court, sir. But all appeal. Asking one particular date, how can you answer? Cost for the petition. Response 610. Post for 2 weeks. On 23/11.
Item number 44, KB Nilsundar, Double Telanganana.
Yes, sir. Then you have to make amendments. You have to argue the matter. You can take it on. Sir, we don't know either. The dialysis. How can I argue? Ask them to argue the matter. Then you have to argue the matters are there. Your colleague. When do you want answer? 2 weeks. 2 weeks. Are demands in favor, sir? Demands in yesterday. Yesterday. I will not extend them by tomorrow. Provide by? Respondent, okay, that's why I'm asking. Cost for the. Yes, the conference response 6 and course after 2 weeks. Independent election till then. Yes, sir.
Item 45 and 46. Please, Rajnikant Reddy, comment here.
Post after the 6 time. 3 weeks. Post after 4 weeks. Independent election. Both are connected.
Item number 47, B. Venkateshwara, M. Manjushri Bharadwaj.
What is matter?
Millard, I'm appearing virtually. Your Lordship may grant 2 weeks time, Millard.
No, you are not bad, madam. Before that matter, wait.
I'm sorry.
Not matter. Okay. People. Okay, cost per. Because time. Post after 3 weeks. Direction till then.
Item number 48 is the Vikram Chandra I money pay.
Yes, madam.
And Millard, in this for the respondent, Millard, I filed wakalat. Millard, they are changing the advocate, Millard, due to some inconvenience on my part. So, Millard, your Lordship may kindly have it after 2 weeks. They'll engage an advocate and file a vacate stay petition also.
Conference for 6 time. Post after 3 weeks.
Oblige.
Item number 49, P. Ramchandra, Mirja and Alipay.
Ramchandra. What do you want?
Request for the extension of it.
Yes, sir.
Then we have received a NOC.
Divided March. Post of 0.6 10. Post after 4 weeks. Divided till then. Excellent.
Item number 50. Consistent law officers, Ms. Mallam.
Yes, sir. Happy to not again. See, order 7 rule.
Two cars on rule 11. Before vacation, senior council on. Yes, here, others here. Ready? Sir, today I have used government number of cases, sir. Yesterday I have deal. And post of
final year.
yes, sir. I performed final year.
This can be taken up as it is not person. Stay has been granted, no vacate file. We heard finally. Ready or not? This is understanding. This is again it's technical.
Challenge for argument is I agent minus before that agreement to be. Yes. I'll put her 2 weeks, sir. I will hear all of them. Next time. 2 weeks only, sir. For 2 weeks.
Item 51, agenda item number 52. G.
Yes, sir.
The notice number is carried. That is where I started the wanted placing file for HIGHCOURT. The injunction order next to the status here, EMA dispute. The only request of the status code instead of suspending here, lost status will put to dispose of food within the 6 months. Till then the status could be continue lost to the exception. Because the tendency here last month is the MRO report also clearly shows we are in the position.
That's important. Let us go to this box.
It is here to 18 license.
Within 6 months, sir.
Their status code with that.
That's correct. That's
Item number 53, Exam Commissioner Rakesh Kami.
2 weeks.
when was the advance granted, sir? April. 13th April 2020. Total for 6 10. Post after 4 weeks. Record.
Item 54, agenda item number 53, Ravishankar Saraswati.
Yes, sir.
The doubt is whether the document hard to refuse. It's draft copy, a copy of the original.
page 5 exactly. It is the last copy of the order. Therefore, the petition filed under order to 1383 it should be not to be marked because good between brothers. Partition got one of the item already partitioned. He brother had got 30 areas. So the document was not to be marked. And you will have to kindly see petition also. Normal copy is you have to kindly see page 10 of petition. Last time was saying the last copy therefore cannot be ordered to one, don't understand. Evidence, secondary evidence. Page 10 last mechanism. Last previously qualified instance, but that for which copy of said family part is filed here. Copy of the said family part. Now we learn in the order page 5. You take it as the last copy of what? Page 5. See that the stage of the petition to came up with this petition to receive the last copy of the partition. Therefore, petition filed as a rate was A3. So partition, whether partition is affected or not. Admissibility and relevance of document can be gone into at the time of taking. But it is threshold.
Still not document.
Yes, it is still not. The with the document, petition to the 438 already. Cannot be admitted subject to relevancy. That is will have the document. With secondary evidence also.
What's your proof now?
The evidence coming up with my evidence, dependent evidence. That can only be of
Yes, sir. Let me application. Number one, the document which is placed before the trial court and trial court refused to take it from credit. No, that has not been annexed to the CRPI.
Page.
Oh, yes, I'm sorry.
So first is over.
Second aspect of the case, if you even if suppose my friend it's a carbon copy, let us see. Because then section 65 has to be satisfied of the evidence. The document cannot be received. Xerox copy is equal to some Xerox copy, carbon copy, or whatever copies. The foundation for the secondary evidence has to be laid. They have to lay the foundation. Where is the original? In whose possession the original is? Even if suppose the original is in my possession, let us say, then they have to follow order section 66. They have to issue the notice first to me to produce the original. If suppose I don't produce the original, then that 63 petition has to be filed.
What is the submit? What is
Category stated it is the same. They are not produced.
Then the second aspect of the case is the stamp duty. Kindly see, the document is insufficiently stamped document cannot be received. Section 35 of the Indian Stamp Act starts with a non-obstinate clause which says no court can receive the document. There is a stamp document. The trial court has rightly at page 5, I will see the trial court's order.
Partition leave composite on wisdom.
Yeah, not. If it is a memorandum of family partition, yes. It cannot, it need not be. If suppose the partition has the contents of the contents of the document.
You see the contents of the document.
Yes.
What they have in between family others and village others.
All these things are.
Not with other person, we brothers sat together, we had family party, there is the question of going for registration.
The translation has been given at page 13. Doesn't show any partition. Today we, page 9, today we are done the partition in the presence of Pushpaya, Sarpanch and the Gram Panchayat. They have the ancestral property of 90 square years house, having 3 wards. We got each 30 square years to 3 brothers. In the survey number 391 of 3 excluded, we got each 2 land for 3 brothers. So it's for the property of Sataya, Yadaya, and Shankaraya and no right. Sataya's property, because he acquired his own partition agreement he made on this day in our Panchayat. There is nothing to show that our oral partition took place prior to this agreement. And they are writing this agreement only in memorial of the oral partition.
మా నాన్నగారు ఆస్తి 90 గజముల స్థలం మోస్తుంది.
Yes.
పురాల పెట్టుటిల్లు సాయివాస్ పడింది. సాయివాలం మా దగ్గర 3 భాగాలు ప్రతి వాటాకు 30 భాగం పంచుకున్నాం. 6 గంటల భూమి దూరం సభాగం ప్రతి వాటాకు 2. గారు పొలం బాలసురాయన అకాడమీలో సత్యయ్య గారు 6-10%, శంకరయ్య గారు 20%. Karavar Vivada Conversation. They got the Sapali was Rasti, other Karavar Ketan. Karaya, very glad was Sapali Rasti, another government.
These parts are irrelevant, only 90. Only one item in the future property is 90 square. Other these are only this document is big. Not to be marked. Only this 90 square years. In that I got only 30 square years. There is objection there.
And kindly see, the signatures will not. Panchas are also signed. So it becomes an arbitration of what?
Terracotta is not by the CRP, sir. Whether the document received or not, that's the only point.
Yes, my submission report is on. Just a minute. The secondary evidence picture has been. It has to be looked into. With respect to section 63, 64, and 65.
I said, this is the Supreme Court, sir. I think this is the Supreme Court. The grand question for receiving documents. That is the regiment, sir. Go to the recently, because that 22 also.
I'm not saying on the delay. I'm not saying on the delay. Kindly see. I'm not delay, sir.
Receiving a document, I'm saying.
Receiving the document, the trial court said, kindly see the trial court's order. Trial court said, original is page 5. Our both sides, second paragraph. Our both sides, the letter counsel for the petitioner submitted that the original family partition date dated 16/4/1998 is with the respondent's plaintiff, and they have not filed the original before this. Therefore, they are constrained to find the copy of the same available with them. This trace job recently and hence it is just necessary to receive the said document by conducting the delay towards secondary evidence. Your Lordship. On the other hand, the counsel for correspondence plaintiffs submitted there is no such document reduced into writing in between them as partition. The same is not known to them. The petitioner has created the said document for the purpose of this case with the malevolent intention. This is a sole permit for the partition of the scheduled property. It is at the stage of cross-examination of the petitioner. It is at that stage the petitioner defendant came up with the presentation to receive the Xerox copy of the partition deed dated 16/4/1998, stating that it was
for this document, that's the Xerox copy. Sir, this is Xerox copy.
Even if suppose it is a copy, let us.
Yes, sir.
But then it is a secondary.
Yes, sir. Ask for one second evidence.
Even that petition. Then we are kindly see the government counsel for the petitioner have stated that the Xerox copy of that award has to be received for secondary evidence, has not come up with a petition to receive the same. Your secondary evidence, what is wrong with the trial court? Trial court has given a fact finding that the law is, suppose something is and instead he has filed the present question number 81, receiving the said document by condoning the delay. Even otherwise, the respondent plaintiffs are denying the existence of the said document in between. Such circumstances, it is not possible to receive the document unless it is established that there is any such document executed in between them and the original is in the custody of respondent plaintiff. Absence of the same is not stopped. Like these are the ingredients of section 60. And they cannot circumvent. They cannot circumvent.
What is 8, order 8?
What is
183
documents. Not the the document which sought to be produced in the court by the defendant and received, but is not so produced, shall not without the leave of be received in its evidence on his behalf and the hearing also. The documents which ought to have been filed along with the written statement and could not be filed for some reason that can be used at this stage. No quarrel about that. But the thing is, the document which is secondary evidence cannot be produced under order 8.1. The thing with the counsel in the trial court did some mistake that cannot be justified here. He has to file an application there for 63, 65 evidence act. That has also cannot be taken there. That say non-provision of law. That cannot be. Kindly see section 65. Cases in which the logical section 65.
Yes, sir.
Cases in which secondary evidence relating documents will be given. Secondary evidence will be given of the existence, condition, or contents of a document. Following cases. When the original is shown or appears to be in possession or power, person against whom the document is sought to be proved, or any person out of reach or not subject to process of the court or of any person legally bound to produce it. When after the notice mentioned, and when after the notice mentioned in section 66, such person does not presume to produce it. So we are in 65 days planning. Then we are trying to see 66. It is a mandatory provision there. Justice Ramna's order is also there. This is 66 for rules as to notice to students. Secondary evidence of the contents of the documents. According to section 65, clause 8, shall not be given unless the party proposing gives such secondary evidence as previously given to the party in whose possession or power the document is or his autonomy or freedom. Such notice to produce it as is prescribed under law, and if no notice is prescribed under the law, then such notice has the court under the circumstances of the case. Why did there such notice shall not be required to render secondary evidence in any of the following cases, or in any other case in which the court thinks fit to dispense with it? Document to is itself a free and formed from the nature of the case, the adverse party must know that he will be required to produce it. And so it's also that all these things are. The adverse party or his agent has the original in the court. All these things mirror are. So my submission before this honorable court is the procedure adopted by my friend circumventing section 65 of the Evidence Act that cannot be allowed. They cannot file a document just like that. to file a document in a proper procedure. Procedure is section 65, which the trial court has rightly said. Trial court said secondary evidence of petition is needed. Then that I am relying upon judgments here. 75 for SCC 64664. Supreme Court here, AIR 66, 57. We just read from the kindly see first minute AIR 1966 Supreme Court 1457. Para 8. Supreme Court that I will just read. This is the 7-member bench judgment of the Supreme Court. In Roman Catholic case, para 8, as there is no document according to the grant of enough conditions, one has to turn to a number of documents from which the High Court and the Court below have drawn regarding what was included. There is of course no dispute that the enough must have been priced, the value at least. That must have been done. Thus, the sole question is what it comprised. We were also, it reaches conclusion that forms were included in the which we will not go over this. Kindly come to yeah. Let kindly see in the middle of that particular paragraph, next page, middle of that, these documents undoubtedly, after that date and then the recipe, these documents undoubtedly would have thrown light upon the matter, but they are not admissible because they are only copies. Originals were not produced at any time. There was any foundation laid for the establishment of the right to give the secondary evidence. The High Court rejected them. It was plainly rightly so. Decided. We leave these documents out of the consideration. The other documents do not show that they are. Then we had 674 Supreme Court also. 7. After hearing the limit counsel for parties, we are of the opinion that in this respect calls for going conclusion. According to clause A, section 65 of the Indian Evidence, secondary evidence may be given of the existence, condition, or contents of the document. The original is shown to have appeared to be in possession of power of the person against whom the document is sought to be proved, or of any person out of which or not subject to the process of the court service. Person legally bound to produce it, and then after the notice mentioned in 66, such person does not produce it. Clause B and G 65 specifies some other contingency. Within the second and the expected relation to the document may be given, but we are not concerned with this process as it is common case of the parties that present case is not covered by this. In order to bring this case, section 65, the appellate file applications was examined as a witness, being at the center of the respondent in order to produce the original transcript of which, according to the plaintiff, he has filed a photostat. There was also made by the appellate that his respondent denied that the said transcript has been written. Photostat copy might be, but the examined the appellate also filed a nowhere stated in the appellate photostat copy has been filed by the appellate was in the possession of justice. There was also further material on the report indicating the original document was in possession of justice. The appellate further paid to explain as to what were the circumstances under which the photostat copy was prepared and was in possession of the photograph was taken. The respondent in his affidavit denied being in possession of or having anything to do with such a photostat copy appeared to the High Court to be not above suspicion. In all circumstances, the High Court gave the no foundation has been laid for reading secondary evidence, the shape of photostatic, requirement my submission before this honorable is that the procedure cannot be circumvented. Now, here is a case where clear case, very open case, that you have to file a secondary evidence petition. You have to satisfy section 65 of HTB. The what circumstances in that? The document has to be filed. And section 66, section 65. Justice Wadi, there are number of there is one another division judgment also.
So here 2010 clearly, this is prohibited judgment of it.
But justice for the 2010 3A report one. Partitions, suit for partition sought to be received. Sought to be received and this is partition list. After secondary stating that originally was correctly given. Third defendant denied custody of the document. Reading that the sub-document, the recorded a finding that the document was in custody of the document. HIGHCOURT had rightly refused to receive it. It was finally covered. So they have to satisfy under what circumstances they lost possession of original. Just to say original is in my possession doesn't suffice. How they got the Xerox copy? If the original is in my possession, how is the how? When and how at what point of time they have taken the Xerox copy? Now this is foundational in the PDs. And in that absence, the trial court shall understand by saying that the original existence of original has not been said. Therefore, that requirement cannot be circumvented under Order 821. What Order 821 says is the document which has to be produced at the time of return state, along with the return statement, if those documents could not be produced, then yes, you can produce with the leave of. Not any foreign documents, any document which is subsequently discovered or subsequently found, not there being any foundation. My submission is CRP list.
Yes, replace
Just copy or any copy of the document. 2 copies taken out of there. And signatures of the all parties are also there. So it cannot be said a copy of the document.
These are not original. These are only Xerox.
Carbon copy, the signatures, some of the parties they have put original signature also on the copy. Therefore, usually we have taken 3 copies and signatures to be on the copy. Because carbon is available, they have taken copies. And the revenge state actually can be gone into the time of leaving of the case. Yes, the sure it cannot be thrown out. That will be in the part for partition among the brothers. The court of first instance.
The judgments were the same situation. It's not read by the court of respondents.
That's not because the judgment will not be contested 1975 4 SCC. They say it is the copy, glass copy.
Copies.
How it has taken we do not
particularly copy, not Xerox.
Why not? They did not copy. Photostat copy.
We have to take a photo.
But here it is not a photostat copy. It is one of the original photostat. The signatures are also there. Only technicality will not say the 6-way petition is filed or not.
There is no original signatures. All carbon Xerox. Carbon not. There is no original.
It is a photostat copy equally.
Yes, sir.
Only carbon when original is signed. If you take a copy, original is signed, it is coming the copy.
So many original equivalent to carbon copy is equal to original document. No. Okay, here goes it. Goes for orders. Sorry. Good for end asking here. For orders. After 3 weeks. Yes. I'm going to start. Yeah, carbon copy. Carbon copy. It's just
Item number 56 and 57, Mohammed Adan K. Yadgiri.
Actually, you do it to directly by petition winner. Because technically, this is technically and I am not winner. Your document.
The law permits it, of course. That's fine, my friend did not have a liberty. We take it so.
Because they say, hey, this is the CRP officer, they will.
Please come with me again. Okay. All happens, my friend, in all this.
Item number 58, 56 and
Please note the memo was missing that when I filed taking objection regarding marking of the document.
About
Somehow 10691623. Time of marking of the document by defendant DW1, I took an oral objection for directed to file a written memo. I filed a written memo taking the very same objection that the agreement contains recitals such as payment of entire sale consideration and delivery of possession. Hence, it is a sale deed and it requires registration, it cannot be marked. Then, with the consent of both the parties, the trial court cannot heard both the parties and pass an order. That order is not challenged in this court. If the lordship permits me, I just refer to lordship memory with my past arguments and continue with 2 citations I will present to it. But I noted to your lordship notice the agreement. Agreement contains recitals such as payment of entire sale consideration and then delivery of possession, and the fact that there will be no concern with both the parties in respect of the smooth property. I relied upon judgment method of Justice M.S. Ramchandra, which says that the transfer of interest in immovable property of above 100 rupees attracts registration and document cannot be marked, hence my application was allowed and the document was issued from the record. Another judgment of His Lordship Justice Gangarao I relied upon, which says differentiate between the stamp duty and the registration act. Even if you have paid the stamp duty, if the document attracts registration, it cannot be received in evidence. But now, my lord, I wanted to see this memo on what basis I have taken objection. This document is before this court. But in continuation of my argument, Lord, I have just laid my hand upon Supreme Court judgment, which clearly says that not being normal. I just read out, I'm sorry. Just read out what I have stated in the memo. May it please your honor, the above named defendant hereby takes objection against the marking of document termed as agreement, which evidences transfer of all rights in favor of the plaintiff, including possession. And the said document cannot be marked as it is by section 17 of the Registration Act. So now the trial court, my lord.
CRP 7021-2018.
Yes, I said CRP 7021. I relied upon Justice Ramchandra judgment. Once again, take your lordship to the same judgment. On page number 27 of the CRP.
Okay.
It says like this, lordship hospital, I just read once again. Page 29 is the relevant portion.
Page 29 of?
29 of my material papers. CRP.
1250 or?
I'm sorry, 1445.
1445. Page number?
Page number 29. In this case, not a document termed as memorandum of understanding was marked. But in this document,
rights were transferred in respect to the same property to the brother. I objected to the same, but the trial court said what is only a memorandum, hence section 17 does not apply. I filed an application to eschew the document, the petition was dismissed. Challenging the same method, I filed the revision. It says like this in paragraph number 15 on page 29. The document that is declaration dated 6/10/2016 reads as under that on mutual understanding and upon our family settlement, I do hereby disown space on eastern side of my house representing 12 for two-wheeler parking to the possession of my brothers, namely Muhammad Abdul Salam, son of so and so, who are the owners of the upper floor of the said building, that they are bound to park only two-wheelers in said area measuring 12 to 8 feet. That the above contents are true and correct to the best of my knowledge, believe and execute this declaration with my fully and consent before the witnesses, and this declaration. The observation of the court. The word disowned in the above document clearly indicates that there is a relinquishment of right of the petitioner in favor of the respondent. Such relinquishment requires registration of section 17(1)(b) of the Act, since the intention of the respondent in adducing the said document evidence to prove the primary purpose that the petitioner had allowed them to park vehicles in the said area, and it is not their intention that it should be marked for collateral purpose. Therefore, the said document cannot be received in evidence because it is not registered. The court below has not only ignored this aspect but also did not go into the question whether the document is properly stamped or not. So in this case also I have read out the entire agreement. But the trial court now is impressed by the fact that the document is termed as an agreement, and that advantage they are taking says that this is just an agreement of sale. It is the recital of the document that will prove the nature of the document. Where I have relied on one judgment that has just passed on 2022 LD, the Supreme Court judgment. Yes, sir. Relying upon paragraph number 30. In this block, they say it was a sale with a condition, but the Honorable Supreme Court was pleased to negate the condition of the parties hearing. Paragraph number 30. But it is still that real character of the transaction has to be ascertained from the provisions of the documents viewed in the light of the surroundings. Since two documents were executed on the same day, the transaction cannot be motivated by way of conditions claimed in view of express provisions contained in section 58C of the Transfer of Property Act. A perusal of the recitals contained in the salient and exhibit PA shows that property was agreed to be sold absolutely for a total consideration of 45,000. The plaintiff had also stated that since possession has already been delivered earlier under a deed of mortgage, delivery of possession in this document does not arise. It was further stated that henceforth neither himself nor his heirs have any right, title, or interest in the property, and the plaintiff is entitled to water, air, right of easement, etc., concerning the property together with all rights, title, and interest, and right of the property. The defendant, his son, and grandson, etc., unto posterity are entitled to enjoy the property without any objection or trouble, either by plaintiff or from anyone claiming the gift. He has delivered the possession certificate issued by the CITB and Khata certificate for transfer of Khata from Bangalore City Corporation. Thus, the language employed in this document is plain and unambiguous, and the intention of the party is also very clear from its recitals. Even the evidence led by parties does not indicate to the contrary. Thus, a careful perusal of all the clauses of the sale deed and the evidence of the court clearly show that intention of the parties was to make the transaction sale. We are also view that since the execution of deconventions is already been established, questions holding the sale deed to be nominal cannot be accepted. So, actually, the recitals do not clarify the intention of the document. I'm sorry to repeat. The agreement says sale consideration is paid, possession is delivered, henceforth I will not have any right and he will enjoy the property forever. Now they want to mark the document without complying with section 17, and this defect cannot be cured. Section 17 is a defect cannot be disentitles them from reading this document is evidence for the primary purpose. Yes, another judgment that I have used on the last occasion, I have placed it in my medical paper on page number 35. This document differentiates between an agreement of sale executed before April 1999 and agreement of sale executed after April 1999. Assuming for a moment this is an agreement of sale, assuming for a moment what they say is an agreement of sale, if it was a document executed before the cutoff date, that is April 1999, it does not require registration. If it is an agreement of sale coupled with possession executed after the cutoff date, that is April 1999, it attracts registration. Continue.
Awesome. So nice thing, madam.
Transfer matters item number 15. Leave Sudhakar T. Praveen Kumar.
Yes, sir. No compromise. Last 3 times. Tell the matter.
We are linking the landlord tenant case we got. Yes. One day or the other, the tenant has to vacate the place. But what we are seeking from the landlord is to increase the lease from 3 years to 5 years. So there, in between these elections has come. There is a back what will happen. To argue this is not the time now. I'm running away from my responsibility. We are trying our level best to settle the issue. This is school. Tenant is a school. That's the reason we want to get a permanent solution to it, not to fight out in the court of law. That's only before this one. It is last opportunity. Can not compromise can happen in the suit also. Compromise can happen in the suit also. Let the CRP be lodging beside the CRP because they are not paying the rent. Instead of 30, 40,000, paying 10,000 rent. To say, I will tell you this doesn't exact. Court has directed me to deposit 25,000. Only then stay was granted as on date every payment has been made without default. Only the stay has been made absolute. Deposit rents, admission rents, the interest admission, let the rent into the compromise cost can go in the school to take some time. Not a lots of deciding every competition. So immediate petition lots of deciding. And happen in suit also compromise. Because not suit is staying. Page 30 additional 5 deposit 5 lakhs towards arrears of rent and continue to pay deposit 25,000. So in the document and this week, I said not paying rents. That's why I'm paying Laganada. Here he was paying 10,000. Instead of 40,000. We find petition the section 15 directly to pay admitted. That petition of all of please whether I'm paying 25,000 or not. That is the court has raised a question. You answer for that. How can you misrepresent facts? I say that only 10,000. My credit is going more. I say 10,000 was paying 10,000 last time I filed a petition. After interim order is paying 25,000. Prior to that, because ILFI the important started saying 10,000. Given as grounds. After this time, the file is 15 petition that was allowed. And one of the admits, watching the kindly court also observed yours. Page 13, watching the kindly. Yes, I have seen. That morning I have seen. Court offers that the interest was that much in the deposit. Both this court was type of interim orders was have to be 25. But now lots of 25 plus 5 lakhs deposit or 7 lakhs. 7 lakhs. 7 lakhs on per order. As a wait for 2 more weeks, sir. Yes, sir. Compromise is not accepted after 2 weeks. Lordship has said next week, compromise 2 weeks, sir. 2 weeks. 2 weeks for compromise. Yes, sir. That's not happening, but I'm saying I have just already paid the serious of the rent. Only Intiman is paying 25,000. Yes, sir. Continue. Next case.
Item number 26.
My amount. After 2 weeks, I will pass on this.
Item number 26 is Sunita Reddy KV Conference.
Yes, sir. No problem. It's not 5 lakhs, but the request is the 4 below
we expect not the unexpected Indian water. But they are claiming the right. We are basing on the input labor. So there are elections to be provided. These are the donor of work that is speed of the that is all the speed of us. Because the delivery is delivered. But though it is not imported, but though it cannot be taken as taken to the effort, it won't not have freedom is not here. When it guidance though that's not up. So you are one become neutral. And when the what is it going got to and also what a social population that we have which is that but I find the arguments are all the number of the setting number of people. The people arguments is based on the bank. Yes. Always one of the arguments are yes, sir. Entire 3 pages. Yes, sir. This is not that the English was responsibility for that we must ask the benefit of the social has today and it should be compulsory. And there is no inclusion for the it's growth of institutional. Writing of the petition for what's the preferred. Why is not the survey of the level is not the release of the policy of the petition there is no objection for the facts. Document is doing the second is the also discuss the market also refer the also the and otherwise the information of the right to export and the so not of the rejection of what lies very stable that need documents instead of relevant because in the grounds of the security of the system and that the unique documents are operating the seal of the by creating a right which is also one of the reports through which perfect presentation of circle. Here this case the earlier government is on the the same way for which the claim right and right in the response to the it has to be listed otherwise. If you not within the right before, necessary right in right, the first should be shift out. Something that the responsibility to not a part of the labor. And every level is responsible for the responsibility has to be properly listed. But if there is
A1 is not registered, and therefore the Guna of the responsibility cannot include the finish over the responsibility. Registered. Infinite testimony, right to the responsibility for the student. How to be open into the able. In order to claim the alleged patent decision, the document execution in order to set a decision which is vital to present the rights of the parties has to be registered. This offer is no property service. The nature of United School and the school, they only share this. The allegation, like contention, the responsibility. Instead of the armed forces, the final application is different than the of the armed forces would be ordered to assess and evaluate the rights provided the about the usability of the document. Which have the yet also therefore in order to make a proper and effective test of the by the also something that is not necessarily covered and that the document has to be removed from the tax is marked as the convention also referred to is not these are the long statements of the education and the other starts from page 800. The Portugal referred with regard to economic stability. Para 8 page 10.
Not para 8.
Yes,
okay, para 8, yes.
Written arguments from the educational difference, but both sides were written. My written arguments are referred. None of the contentions were written. Forwarded or raised. Discuss different. Simply para 13. The different characters the different cited by the traditional subject are also were mentioned on the 17. And para 13 was simply stated here. Again, the submissions
Para 10 is there. Para Santa considered. Frequently argued. Suppose yes, sir. Consider argument. As a judgment also the other mentioned, all judgments mentioned. 17. Up to 17 petitioner.
Yes.
1 to 5 only for respondent.
But where is the response?
Yes, sir.
The sufficiency will be good. It is just a representation.
Yes. Consider, sir. But the class reading, sir. The class reading can mentioned here, sir. The other also mentioned all judgments.
That's not mentioned. There is no discussion.
How can each and each page cannot mention in each page? Judgment, sir. But the class means
single word saying that's all. Not even consideration.
Or meticulously reading sentences filed by the both parties. This court is concerned with that.
Anybody ever was informed? They have to be
marking as a even
when they are not even including the counter. When it was not important, they did not mention anyway. They only say that's why it was important. Even after that, taken into account everything. Even though it is a registered document, it is taken as a purpose. When the record is into
reading section. What we have mentioned here is clear that minister says it's sought to be relied on only the possession of the property. Using arbitrary criminal and the citation related to the conditions are not. But I have raised my 9 grounds for the interested. One of the grounds was discussed. But the same thing was considered by what the consideration of
The service matters, the cultural electric.
therefore, consider your my they are referred to the order. They don't consideration of how those groups are not up to you. They go for discussions. But the very much not that you want.
Yes, sir. You want to remind the matter to the court window. Yes, sir. Yes, that's all. What's over? Okay. The reminder, you don't want to give the judgments. Passing very silly matter to give the other judgments.
Just see the page 21.
Yes.
Page 22 is paragraph 1. The plaintiff is the absolute owner and possessor of the open land, dismantling all his property bearing on the structure to an extent of an acre. Periods, situated cluster village, Alipanda Mandal, Varangal. The plaintiff acquired the said property through the registered gift settlement deed executed by his natural brother, the Kula Basket Corner, and the registered gift settlement deed 5/2003. So the first document through which I am clearing property is the registered deed executed by his brother. This document now which I am disputing is a notarized agreement to which the brother purchased. So therefore, this notarized agreement was also filed to show how his brother came into possession. That's so therefore they paid stamp duty and penalty and imported the document. Court received it and marked it as exhibit. Simply because the document is marked as exhibit, everything is not closed. They are entitled to cross-examine. Even the judgments they rely, they have reported the same judgment at page 33. They have reported AR 1994 Rajasthan judgment, where documents exhibited effect does not debar the court from removing the question of its admissibility, mode of power cannot be questioned. So therefore, let the cross-examination. It is still open to them. This document cannot be put into a lawsuit. Simply because document is exhibited, everything is not over. So if they are confident that this document is not liable to be taken into consideration or not to be payment of registration laws, all those questions left open. You may say that. You may say that. For that purpose, the judgments they have relied, they are not relevant. So the government judgment here, I will see that every officer has got his own way of expression. So therefore, it can be simply because each and every judgment is not discussed. It cannot be said that the part of the other judge is wrong. So every judge has got his own style of passing an order. Therefore, this is not a case of we have to the benefit set on section 49 below. This can be put into a political purpose only. Court is also not inclined to like political purpose, the court wants to keep, that's all. Last paragraph. Paragraph 13. After hearing the submissions made by both the learned houses, meticulously reading the citations filed by both parties, this court of review even was informed prior to the hearing executive as such, even though it is an administrative document, it can take into evidence for political purpose by the respondent plaintiff in the present suit, and a reading of section 49 of the Registration Act, it is clear that unregistered plaintiff are to be relied on only to prove their possession of the property. They can be admitted into evidence under the third provision to section 49. Hence, exhibit cannot be de-exhibited at this juncture, and the citations made about the case are not squarely applicable to the present case. But we point is also. So only to look into the aspect of possession, we don't want to see that. That's all. The main primary document mark 2003 So that they have not challenged till date. 2003 Yes. So therefore, this is not an order to be interfered with. Therefore, I query on the court. Dismiss the revision.
Yes.
We have taken specific law to check the bed. Section 17 of the documents not which they have named it is compulsory not registered to document. There is no exemption on document.
What equitable payment?
Not agreement of sale.
You don't say.
Not as the agreement
Not agreement of sale. 47. 41. Through which they are making title to possession. Yes, because it's important in terms of freedom to do.
How important?
Here is only not document agency.
They will get decided in the style only. Aspect of the date meeting again already marked by this.
Suppose they want to sell it, not can't be even registered. If not, they want to sell it. Not there, that will not be. Once the documentation is not registered, now here reporting does not given but it cannot be not given to the records because they are claiming title through it.
And only for injection suit, sir. Question or not? Good for injection only.
After possession, you not title and both last two times.
Not a declaration, only for sir. Good for injection only.
Even the my submission is not 17 one concept to picture and it says it is compulsory registerable document. And there is no exemption for executive section 49 of the Act.
Because fair person only the second time it is not for the only purpose only they are taking into account. Even not a second document.
The document itself is not registered. But on which one they are claiming.
So that important the document. What is 17 then?
Section 17 is not considered by the
Section 17 of Registration Act. What about 49, sir? Section 49.
But there is no exemption for the implement of the section 49. Or it's closed, and it's closed.
What is Section 49? Effect of non-registration documents required to be registered. To be registered may be received as evidence of a contract. All evidence of any collateral transaction not required to be affected by registered instrument.
Not required to affect all the
Evidence of a collateral transaction not required to be affected. By the record.
By mentioning section 49. What's the one? The photo consider all these aspects. We are
Yes, sir. Same. Yes.
It's a party and proviso is helpful for legal purpose. Then they are leaving section 35 of the Stamp Act. Section 35 of the Stamp Act to set payment of stamp duty and penalty. That we paid them for what? They are paying stamp duty and penalty. Again, very last week, no, this time. That is the dispute that they have not paid, then they can raise it. That is related, clearly applied, it's an impounded document.
This instrument shall be admitted in evidence on payment of duty. Same has been chargeable. And with penalty, I think.
Yes, penalty.
10%. 10 times. Yes, it's a month will convert 10 times for this portion. So then take in account as the trial, sir. This is not for title, sir. This is only for the injection suit. No, not for the declaration of title.
They are taking title to the donor.
Yes, sir. Okay, consider them. Give the judgment. Consider pass out. So you want every judgment you have to mention and then para and what is the reasons for? What is the relevant para? You have to mention and give the synopsis there. Let's post for orders after 2 weeks.
Item number 42.
Cost is the measure cost to council also.
That is only served on them. We have informed the council below.
Informed.
Yes.
Okay, same on morning it's not done. Yes. Actual date or date of next date of hearing, the judgment date is 28. 4 weeks. 4 weeks. Yes.
The order will be issued.
Tomorrow, sir. Tomorrow.
Much of this.
Contribution item number 56 and Muhammad Adan.
Yes, sir.
Continuation lines from the judgment on page 35 of my material papers of CRP 1445.
Yes, sir.
Also squarely applicable. I just read the instruction partner.
Yes.
This revision petition is the 7th dependent in the suit. The respondent to our date is the respondent 3 to 13 other dependents who are shown are not necessary parties to this revision. The suit is filed for declaration of title, recovery of possession, mandatory injunction with 7 different.
So you're reading what entire document you want?
No. On the introduction for better appreciation. What was the issue involved? Then I'll come to the relevant.
Yes, sir.
But in that case, also same memo was filed objecting to marking of certain documents. But on the basis of the objection, the trial court rejected the documents filed by the plaintiff in toto. the Honorable AP High Court was pleased to differentiate, saying that this set of documents can be distributed into two parts, differentiated into two parts. One set of documents that were executed prior to April 1999, and other set of documents that were executed subsequent to April 1999. Only those documents that were not executed prior to April 1999 were considered to be eligible to be marked. And those documents that were not executed subsequent to April 1999, the court held that these documents attract Section 17 and they were compulsory registrable, and this cannot be marked. Yes. So I will just come to the relevant portion, paragraph number 6 and 7. Document can be rejected to be received in evidence among other grounds, mainly on the ground of want of registration or want of proper stamp duty. Both these aspects are governed by two different enactments. In so far as registration of the document is concerned, Section 17 of the Registration Act lists the document which require registration. Section 49 of the same Act speaks about effect or non-registration of documents required to be registered. An instrument agreement of sale, immovable property of value of 100 and of course was made compulsory registrable by an amendment of the Registration Act 1908 by incorporating Section 17(1)(g) by Act of 1999, which came into force effect from 1/4/1999. Therefore, a document of agreement of sale executed prior to 1/4/1999 does not require registration and cannot be objected to be received in evidence on the ground of want of registration. If we adopt this test, only two documents shown at serial number 7 and 14, which are agreement of sale dated 21/12/2009, original at 99 but corrected as 2009, and agreement of sale dated 16/9/2004 require registration. Then I skip the section 49 which speaks about the exception. Paragraph number 10. Since they are not registered, they cannot be received in evidence except for collateral purpose, which is permitted in the section 45 of the Registration Act. Here, when they file this document, they are not using it for collateral purpose. Then we also may kindly take note the paragraph number operating portion, paragraph number 15. Therefore, the rest of the documents of agreement of sale not used by the amended provisions of the Stamp Act of Registration Act cannot be objected to the received on ground of want of registration of stamp duty, provided they are executed by paying stamp duty or something. The trial court without examining all this erroneously rejected at one stroke all documents of agreement of sale to be received in evidence. So, part of the document executed before April 99 were accepted, subsequent to April 99 were rejected. So also in this case, this document that they have created, I am not even admitting the genuineness of the document, only going by one of the present facts of the case. Executed, alleged to have been executed in 2001, required registration because it evidences possession and delivery, evidences delivery of possession and transfer of all my rights immovable property in favor of the defendant in this suit for a specific purpose. But now, in these facts and circumstances, may I draw your lordship's attention to the order how the trial court has dealt with the issues raised before it on page number 6. MCRT. Just one or two paragraphs, the court has dealt with the entire issue of registration and stamp. At this stage of marking of documents on behalf of DW1, learned counsel for the plaintiff raised objections in marking or agreement of sale, even though the said document validated because of its non-registration as required under section 47 of the Registration Act, and hence the said document is not to be admitted in evidence and clears the grant from judgment reported to so and so. On the other hand, counsel for submit an unregistered agreement of sale which is properly validated, which can be received in evidence in a suit for specific performance, that it has created a right to obtain another document in support of which the argument is relied upon student citations. On hearing both sides and on principle of the case law, the judge both counsel court is of the opinion that the case laws refer to the plaintiff counsel are different from the present sets of facts, whereas the case laws refer to the defendant counsel squarely after the present set of facts, and the court by placing his reliance on the citations filed by judges. Counsel for defendant is inclined to mark the unregistered agreement of sale in this present suit for specific performance of agreement, which is evidently validated by paying the requisite stamp duty and penalty. The said document is question will not come within the purview of section 17(1) of the Registration Act, and there is a specific performance for which under section 49 of the Act, and an unregistered agreement can be received as an evidence in a suit for specific performance columns 1 to 10. So here is the case. Case. Almost identical. The information is when one party is saying that a particular document is the same deed itself, and that the covenants of the said document shows that rights are transferred, possession is delivered, and then one other party is saying it's just an agreement of sale. The court have discussed the covenants of the document and then said that see, these are the covenants of the agreement, which according to which I gather an impression that this is only an agreement of sale. When I am arguing before the court that this amounts to transfer of all rights, and then I am relying upon judgments
which says that transfer of rights, tax section 17, the court ought to have discussed all those issues. Simply by saying I have collected this citation, I have collected this citation, not applicable, hence document is received in evidence will not be appropriate, to my understanding. With due respect to the trial court, should have discussed, because it's a very serious issue where a document attracting section 17 has been received in evidence, which takes away my valuable rights. Nothing is discussed, at least in the court had opened the document, which is termed as a. Now also, if I will bring it to your notice, the court has accepted this document to be an agreement of sale. Time and again arguing that this is not an agreement of sale. Please see the covenant. It is the clauses of the document which will decide the nature of document, not the title. Title they have said agreement, but that doesn't make it an agreement of sale. I won't trouble you, Honor, by reading the entire agreement once again. I'm sorry for repetition. Rights are transferred, possession is given, what else was required, the law is very clear. Should not have been received in evidence, should not have been marked. The very big order of the due respect to the trial court. Trial court has rejected my contention. This is the case where it has to be either remanded by or I need to allow to pass an extra order. And saying that this document is the order as your also knows. An order without reasons is non-existent in the law. Yes. This is also a settled law. How do I gather information that how my contention has been rejected? Which portion of the judgment relied upon was not sufficient enough to give an impression to the court that in fact section 17 nothing is discussed. Yes. Yes, sir. That's fine. I will make one problem with the better. Yes.
To send the document to issue discharge for purpose of paying of stamp duty and penalty. Next page, next page number. Next. Originally, suit is filed for stretching purpose agreement based on the fixed agreement dated. So, and the same is coming for evidence of action. Present the record online. Concerning case of the petition, this court is inclined to allow the present petition and moreover, exponent rights. Petition, this court is inclined to allow last file is counter to challenge the case of petition and even the present petition is allowed to no petition will be passed to the department. Moreover, they avoid the material of the and in absence of the counter file. This court that the present petition is to be allowed. I pray for by directing the section 20 versus permission of the 28, 24, 8 district is Telangana. So, I have this prepared in the yeah, please, 17. Page number 17. First thing is, they not opposed, not filed you. They have filed petition for the purpose of marking the document. They not opposed, not filed count. The petition is allowed. They are going to file the page 17. They have the number 37 here 20. This year was page 19. Para 2. Page 19. Yes, sir. The application I number was filed by the petition to section. So I to engage stamp at review section so and so. And to send the original unregistered officer of sale date. 2480 so on the executed by different number of late street to receive the advent of the different number father of the different number 326 of the plane to the district is or Nagata South Africa for importing the same by paying the equipment request from the client channel 21 there are several states. It is pertinent to note that the defendant failed to receive the application. Defendant failed to receive the application despite filing the file application filed in INO before trial court, whereby the trial court has specifically mentioned in the order including that legal counsel for the respondent defendant reported no counter. Therefore, I will regard to the facts of the present case since the original should be filed for specific performance agreement of sale dated 24/8/2009. Statement was filed long back and suit is being adjourned for trial. You are now present suit stage your order coming to argument. PW1 examine, PW2 examine, DW1 examine, DW2 also cross examine. Extravagant. This is the third round of the case, CRP. The court directed the office to send the agreement of sale dated to the distinguished informing the same with the required sample and page 23, second first pair. This CRP number so the memo minute, they filed memo before the trial court, taking the referring the CRP number. The memo filed for this number, they filed memo referring to the CRP. This is a CRP in connection of suit for the perpetual injunction. CRP number 7021, single judge of the school, a suit for perpetual injunction document was proposed to be marked to the image of sale, which requires compulsory decision. The document dated 6/10/2006 was in the form of the declaration, wherein the word is no longer usable, which amounts to the relinquishment right. Thereby, it was held that the document should be executed and cannot be admitted. This is super specific for the relying act before the trial court, they filed memo citing this CRP. According to the last super specific performance. And page 24, paragraph 12. I carefully pursued the principle laid in the above decision. The law is well settled that if the court finds the document to be insufficient, it can call upon the party to make good the deficit and pay penalty not exceeding the consent. Here, in the instant case, at the request of the party, the document was referred to the district registrar rather than the South Account. Because reporting the required sum to jail penalty and the suit based on the judicial agreement of sale maintenance. Merely the document is undisturbed, it does not comfortably issue in the wake of the parties, and the document can be issued in the evidence even for collateral purpose. And next, paragraph 6, whereas the facts of the present case are the quiet district. Here in the instant case, the suit is filed for specific purpose of agreement of sale, and the revision petition based on first defendant did not receive the application before the trial court, and the legal counsel for the revision petition from 6 to report at low counter. Consequently, trial court was under the application directly. This I filed petition before the lower court for purpose of marking the document to send the document to district registrar. They not resisted, not filed a counter. That was allowed. And thereafter they filed CRP. CRP also dismissed. Yes. CRP also dismissed. And last figure, page 26. However, the revision petition defendant is a liberty to raise all the sub-objections that are raised here during the trial, the time of executing the document. In the result, the civil petition confirm the order to but marking my should you know they next my final page 46. The all rulings filed before the trial. 2009 283 146. Registration Act 1908. Section 49 ruling section 17(1). Unregistered agreement of sale can be received as evidence in the suit for specific performance under the provisions of section 49 of the Act. This document will not come within the purview of the section 71 of the Act. Dismissal of the application filed by the petitioner. The lower court for framing a preliminary issue regarding the maintenance of the suit for specific performance of unregistered agreement of sale. Section of religion petition. Page 15. And the next 47. 47. The respondent here in decision is both applications. The trial court has dismissed both applications on the ground of the no merits in those being agreed by the defendant is prepared to deal revision petition since the issue you are both in matters in online the same they are is the common order is part. The condition of the revision petition is that the suit was filed by plaintiff for specific performance of an agreement of release and agreement of state. Therefore, without the registration of the said document, it cannot be enforced. Hence, the issues cannot be maintained. We further submitted the meaning of section 71 of the decision and the agreement of sale is compulsory registered. And as the suit in the agreement are not registered documents in the suits are mentioned. The lender counsel for the respondent submitted that the previous section 49, this is like exempted the section payment of the basis of in the present case. They respondents are own brothers. Last 20 years back, the petitioner sold the property to the respondent. Now, after 20 years, they issue legal notice to the respondent stating that you are licensee. Your licensee, please vacate and pay the license fee. They filed suit for eviction in Miller, subsequently issue legal notice, mandatory legal notice, and filed suit for passive performance. Both suits are clubbed together. Both file is commencing in the eviction suit. Common evidence is going. I filed suit for passive my document, social documents, and we paid stamp duty and penalty. It's a special document. Super specific document. The citations filed by my friend with regard to declaration suit, partition suit. The rulings they filed is resulting in the loan court is fairly disregarded. Page 50 million. 2010 code ALD 8448. TSHC Act 99. Section 17 to be section 46 for you. Document may be creating right to obtain another document. In the present case also, Miller, they being the both brothers, own brothers. No, registrable, not registrable as it is not conclusively extinguish the right in the dependent vendor. Document can be received in the evidence of control. This is the contention of the other part. This document is not the admitted in the evidence because of its non-registration. As per the law, this document prescribes that the entire amount has been received and position was also delivered. That since it is still an unregistered document, though the stamp duty and penalty is required under section 47 of the Act is paid on it. It is not to be admitted in the capacity of the sale deed or in the capacity of the sale agreement. The contention of the division petition, this is same contention arising. Their contention will not the everything is over, the delivered position paid the entire sale consideration. Next, L. Though the district collector for the purpose of stamp duty and penalty treated exhibit A1 in the present case as a sale deed. Conveyance cannot be made under the unregistered sale deed under section 54 of the Transfer Property Act. The distance of the document on hand clearly shows that the defendant undertook to execute separate document at the instance of the plaintiff, though he received the entire sale consideration and delivered the position of the property to the plaintiff. As for section 72B of the Registration Act, when the document creates title or the interest in one party, the extinguishes any title or interest in the other party, then only it is registerable. In 2001, one ALD force partner, the court has categorically held that when there is a restriction in the agreement of sale that the vendor shall execute another document at the office of the sub-registrar, and then the required clearly mentioned below by entire by itself did not conclude the extinguish the right in the vendor. Therefore, by virtue of the provision of section 49 of the said act, does not require this section. The present case also, though the entire consultation was paid and position was delivered, the defendant undertook to execute another document in favor of the plaintiff at this instant. In the light of this complaint and circumstance, the clause that the defendant sold the property to be enjoyed by the plaintiff does not conclusively extinguish the right in the defendant and hence not require registration. Next, AR 2002 Police Officer specifically back registration. Good for specific performance can based on the this agreement of sale, specific performance, agreement for sale, specific performance, specific finding arrived at the agreement for sale was a valid document and to be executed by the party. Time stipulated in the agreement also clear. Leading as to readiness and willingness was required since it was in the present case there is a no balance sale consideration. No balance sale consideration. They paid entire sale consideration. In police also delivered. That's what the section.
Senior counsel, please, sorry.
per the section 5 of the limitation, part 2, article 54 Milord.
Limitation.
The Bail Act. Only one more copy. Section article 54 part 2 schedule part 2 Milord. Section article 54. Next.
54 is.
Page 123.
Yes, sir. 54, if you have some contract, 3 years, what?
Page 123. The agreement of this.
There will be notes of the other, sir. Yes, sir, notes of the other.
When there is a due of this not performance, there is any balance amount due, the agreement of sale will be for 3 years only. Whereas in already in present case, this agreement of sale comes under part 2 article 54 Milord. What says part 2 54? Case of the plaintiff therefore covered by part 2 of the article 54 of Litigation Act. Whereas under time begins to run when the plaintiffs have noticed that performance is refused. It is the plaintiff's case that they have been in position of the issue plan since 1995. And when the defendant filed suit for against in 2001 for declaration of title and injunction, in the present case, they filed eviction case against injunction by issuing the legal notice on 71 demanding the execution. Thereafter, the legal notice demanding to execute the research sale. Demanding the execution of sale and when they refuse to issue this file, according to the plaintiff, cause of action arose for filing the suit for specific performance arose when the defendants issued reply notice refusing to execute the research sale in their favor. Plaintiffs should plead that there are cordial relations between the.
Sir, why are you doing all these things? Only for
they saying everything is over. They made their arguments before the lower court also, before the Supreme Court also. Total and cancellation paid. Milord, 2001 agreement of sale executed. 2001. Agreement of sale executed. The cause of action arose when they issue legal notice, they refused. This is also filed within limitation also. Limitation also. Next. Page 60 Milord. Compact. Importing of document, letter containing the terms and conditions of the agreement to loan property. Nothing to show that the rights and interest in property were actually created by oral agreement. Letter only incorporated its letter. Letter is question is instrumented section 214 of value to be impounded for non-payment of stamp duty. In the present case, also that only even the for agreement of for specific performance is maintainable on the basis of letter also. Even letter also. Present case, there is agreement of sale. The results clearly showing they have to execute subsequent document, registered selling, whenever the party demands. 62 Milord, page 60. Page 62. 2001 to the 114 SC report. Compact 1899, section 38 and 47A. Document produced in the court. If the court finds the document to be insufficiently stamped, it can call upon the party to make good the dispute and pay penalty not exceeding 10 times. If the party agrees to it and pay the dispute duty and penalty, the document can be straight away admitted in the evidence. The party refuses. The court has no option except to impound the document and forward it to collector. The application of section 47 does not thus not at all arise. In the present case, the trial court should have asked the appellant it finds that the instrument is insufficiently stamped so as to whether you will remit the deficit portion of the stamp duty together with the penalty amounting to 10 times of the present case also will not file application, you not resisted, not filed, thereafter filed CRP also dismissed. Simply you file the memo quoting the CRP number. You know, they started with CRP petition. Documents they filed. They are the 14 part.
Yes. Father is please, sir.
They are doing only ruling page 27. They relying on the ruling studies. Page 27. Yes. Page 27. This is a declaration. They relying it. Whereas present should be specific purpose. This is a first judgment 27. This is a declaration. And the second ruling will have page 31. This is a partition should be. The partition should be. The file ruling. Page 35 is a. This is a super declaration like title required opposition. Not applied to the present. All of citations not relevant to present case of sector.
Okay. Yes, the reply. Yes.
The answer to the first objection taken by the other side that I've already lost the CRP against an order of the trial court wherein they were permitted to pay this deficient stamp duty is concerned. Stamp Act is different, as you also know very well. Registration Act is totally different. Though did not raise any objection before the trial court with regard to sending the document for accounting, but that does not mean that my objection to take, but my right to take objection to the registration is also gone away. Stamp Act is a fiscal act. If they want to pay $100,000 on the government on any document that they produce before the court, I have no objection. I cannot have an objection. That's the second law. Because what they are doing is they are paying the money to the government at the end of the day. I cannot come in the way. But when it comes to registration, I always have a right to take an objection that this particular document cannot be received in evidence. That answer lies in the judgment note I have filed on page number 34 of the CRP 1445, because they have been arguing the same thing. That's why I had filed the judgment beforehand. What it says is the Stamp Act is a fiscal statute dealing with payment of stamp duty or instrument as defined under section 214 of the Act, and payment of stamp duty is a source of income to the state exchequer. The presiding officer of the trial court has statutory obligation under section 33 of the Stamp Act to inform the document on its own or to send the document for informing on application of the party. However, such defect can be cured by collecting deficient stamp duty and penalty as per law. Mere importing of the document does not obligate the trial court to receive the same evidence, and it requires registration also under the provisions of the Act. No doubt the law is well settled that as per section 49 of the registration, no document required by section 17 or by any provision of the Transfer of Property Act to be registered should be received as evidence of any transaction affecting such property or confinement of power unless it has been registered. So the contention of the other side that because I have already paid the stamp duty, a document is informed, and that is what the trial court has urged. Because the document is informed that you have paid the stamp duty, hence the defect gets cured and it can be received evidence. That is one defect that we cured. The second defect is incurable, the defect of registration. There is no provision to cure the defect. Within 4 months from the date of registration of the document, he has to produce the document to the registering authority to get it registered. Once the 4-month period is over, you cannot get this document registered. That defect is incurable. On the other hand, if you also see the document that the other side has filed is also an answer to the contention raised by the citation, on page number 52. In my favor, the contention that I have been raising before the court below and also before this court, that maintain a suit for specific performance under the Contract Act, I should perform some part of my obligation now and promise to perform some part of the obligation in the future. If that is the case, then it is an agreement of sale, you can file a suit for specific performance. But is there any such covenant in the document that we are fighting on? Any document wherein I have promised that I will perform some part of the obligation in the later stage by way of executing a fresh document? That is what this honorable court has said, and I am relying on the judgment that is in my favor. Page 11th paragraph. In the present case also, though the entire consideration was paid and possession was delivered,
the defendant undertook to execute another document in favor of the plaintiff at this instance. This is what will bring the document to the purview of specific performance. Let my friend now show any covenant, any clause in the agreement that we are fighting on which says that I promise to execute a fresh document in the future. If that is the case, I am out of the court. If he says so that I promise something in the future, I am out of the court. Yes, your document is an agreement of sale, and all the citations you are relying upon aptly become a bigger case. Only if it is an agreement of sale. And how do you decide? I'm putting a question to myself. This is what the exercise trial court should have taken. Court should have looked into the covenant. That is what I am not arguing. Court should look into the covenants to decide what is this document. Simply going by the nomenclature will not be sufficient. And that is a mistake committed by the trial court.
Yes, sir. Okay,
So far as the attempt of the other side to distinguish by judgment are concerned, the judgment may arise out of different nature of goods.
Yes,
but the ratio decided is what kind of a document requires registration, whether it can be received in advance or not, is the ratio rate of the report. Yes, that I have left to your lordship because two planes are now connected in joint trial is being headed. Yes. That one plane can be rejected or not is the question of problem for the court. Because
cannot reject the part of the trade.
I'll leave it to you. Meanwhile, the lordship can say not to proceed further because TWT also cross-examined. Now, court is saying with advanced arguments. Also, the delay aspect. Yes. Also, the delay aspect. Dependent mark the document in the bag and that's why I am here. There is no delay. Yes. It was my own case. And you are in position.
You have no objection?
They are seeking stay.
Yes. Then they have grant stay, sir. Huh?
I have to seek a stay. Yes, the prime revision is organized.
Yes.
Position of the property.
Sir, I am granted. You are. Then it will be other posting in the OS number source. What is the OS number?
OS number is 22, 74 or 78.
22?
74 or 70.
That's 403.
And the 1194 of 80.
1194.
94 of 80.
1194 of 80. Yes.
Item number 58 and 59. Me, Naveen Kumar.
Change your name. Who's the respondent? Nobody. Huh? Constable, we can see some post after 4 weeks. 4 weeks, not like the work of it. Without body or body. After 4 weeks, sir. We did after 4 weeks. Complete the 4 weeks. Next case.
Item 68. Item number 61. N. Hindusena Reddy, S. Surendra Reddy.
So this copy will
the constable petitioner. Please stand for the constable post after 4 weeks. Till then.
Item number 62, 63. KB Village 1.
Dismiss. Constable both matters, sir. Both we are facing. Council. Petitioner. Permission. This suit was dismissed on 24/8/2023. No cause for it. We are Yes.
Item number 64, de-issue of single swelling.
Repeat petition of the request matter be taken.
Post for response 610, post after 3 weeks. Yeah, not respondent.
No,
Okay, constant. Constant. Petition 610. Respondent.
Item number 65, here imperative.
April. Post for conviction, post after 4 weeks.
Item number 66, Mr. Kumar, need another line.
Yes, you for the petition also.
But this CRP is directed against the order, which a rent control case getting raised. But I am the landlord. I filed a rent control case under the provisions of the Buildings Lease Rent and Eviction Act, which is special act. Respondent filed again under Order 7, Rule 11, seeking rejection of the rent control case. That person has been allowed by the learned rent controller, because that correct is present here. The rent control act is a special act. TPC provisions are not applicable. Said by various.
Yes.
There is no applicability of Order 7, Rule 11 to a rent control case. It has to go on the basis of their case is that it's a petrol pump.
Yes.
I am the landlord.
Park petrol. Okay.
Yes. They say that it is a vacant land. There is no building. When there is no building, buildings rent lease and eviction act is not applicable. That is the growth. But that's a matter which has to be gone into at the time when evidence is let. But when you see the order under it.
Yes.
Page number 6.
What is the rent per month?
That is below 3,500.
3,500.
Yes. That is not the ground.
Yes.
No, that's the ground for dismissal of the case.
Yes.
Now, already it is still feelings. There is no evidence on it. Yes. They say that rent is above the school rent of 3,500.
Not the civil code.
Yes. But the court says that it is a vacant land, buildings lease rent and eviction act will apply only to a building. Since there is no building, the rent control case RC number 70 of 22 is rejected under Order 7.
Yes.
This is totally erroneous. Page 6, the orders.
Yes.
Idea number 72 of 2022 is filed by the tenant, Bharat Petroleum Corporation, correspondent in the RC number 70 of 22. And Messrs. Palladium Real Estate, Palladium Real Landlord, execution petitioner. This petition is filed by the petitioner respondent, the order 7 to 11. Federal section 151 of the Civil Procedure Code, praying the honorable court to reject petition filed by respondent petitioner hearing in RC number 17 of 2022 on the file of this court. That is the prayer. That's the brief governments of the petitioner. The petitioner respondent submitted to the court does not have jurisdiction to entertain RC 17 of 2022 filed by respondent under section 10, so clause 1, that is surplus, is the way to default. Ground of eviction, PP Buildings Lease Rent and Eviction Control Act. The act defines building as under. Building means any house, or part of house, or let to be let separately for residential, non-residential purposes and improves gardens, etc. This is the definition of the building permit under the Rent Act. After the definition, the petitioner respondent further submitted that from where perusal of section clause 3 of the act, it is clear and evident that the building does not mean vacant land. the matter pertaining to vacant land do not fall under the scope of the Act, as the Act is fixed deals with the matters in relation to buildings. Petitioner respondents follow subject of the project case. It is in relation to vacant land that was leased out by the erstwhile vendors of the respondent to the petitioner hearing, which does not involve leasing of a building. The petitioner responds follow submitted as per the lease deed, where document number 964 of 1962, it is very clear that 1962 was vacant land rights. RC was filed in the year 2022. Sections have come in the building. Then there are the 3Ds. I can see how it is constructed. Page number 12, paragraph number 8. Yes, sir. Rejection of claim, order 7 level has been extracted. If we see this particular extracted portion, the claim shall be rejected on the following cases. A, when it does not disclose a cause of action. When the relief claim is undervalued. C, when the relief claim is not properly valued. D, where the suit appears from the statement in the claim to be barred by any law. It's all about suit and claim. The analysis or the finding that is recorded is page number 15, paragraph number 14. Reviewing the documents filed by the respondent along with the additional petition counter filed by the respondent. Respondent himself admitted in his counter affidavit in the petition that initially vacant land was let out by the erstwhile vendors of the petitioner to the petitioner defendant. The petitioner respondent for running a petrol bunk and the respondent and built superstructures over the vacant land with the permission of the lessor. Now, the main question that I raise is whether the vacant land comes within the definition of building or not. It is perfect here to go through the definition of building. Again, building definition is extracted here. Para 15. During the course of the argument, the petitioner argued that the subject matter of the RC petition and rent control petition is mere vacant land and does not come under the definition of building. Under the Telangana Building Lease Rent and Eviction Control Act 1960, earlier it was AP Act. Yes, therefore, the court has no jurisdiction. Then land council petitioner relied on, so it's a decision reported in 2007 480, where it is said that vacant land does not come within the definition of building enjoined under the provisions of the Telangana Act or under the provisions of the AP Act 1960. Since definition of building is same under the AP Buildings Lease, Rent and Eviction Control Act 1960 and Telangana Buildings Lease, Rent and Eviction Control Act 1960. The facts of the case are similar to the present case and the judgment is applicable to this case. On the other hand, counsel for the respondent argued that the primary purpose of the lease is to be considered, which is running a petrol pump. And the petition schedule property was structured, that is constructed on land, becomes amenable to the lease as the same is constructed keeping in mind the primary purpose of running a petrol pump, which is it requires structures and therefore the lease is amenable and the structures in the land fall within the scope of definition of the building as per the Act. Whereas council has relied on various decisions which are as follows. That the decisions are quoted. Then at paragraph number 18, at page number 18, in all the above cases related by the relevant council to the respondent, premised under the lease was land with superstructure standing thereof. However, the point of decisions there is altogether different. Therefore, the decisions are not applicable. It is clear that the Act thus covers buildings, which means a house or a hut or a part of house or hut, let or to be let separately for residential or non-residential purpose. The crux lies in the fact that it is the hut or the house or part of which is initially let out or let out. The lease would embrace the grounds, garden, outhouses separate to such house or hut, what the law contemplates is the letting out of the building. Then by fictional definition, open lands appropriate to the building are covered by the tenancy. It is thus clear that unless and until there is a letting out of the building, the lands and gardens pertinent thereto cannot be included in the building. Relying on the definitions, this court finds that what has been defined in the present case is the vacant land, and only not building or part thereof has been demised under the lease. Then para 21 is the conclusion. After reading all the above citations and definitions of buildings, this court comes to the conclusion that this court has to see what was leased out initially, whether it was only vacant land or land along with superstructures. If initially vacant land was let out and later on superstructures are made, even with the permission of the lessor, it does not come within the ambit and definition of the building under the Act. Even if the major portion of land which is let out is vacant land and small superstructure is appropriate to the vacant land, then it would also fall under the definition of building under the Act. In the present case, it is admitted that only vacant land was subject matter of the lease, and this court relied upon the citation submitted by the land council of the petitioner, that is Kishanlal Kandasari District Mills Nizamabad versus Dinkar Maharaj 2004 ALD page 2, wherein it was held that vacant land does not come within the building under the Act. Therefore, it seems that neither in the form or in substance was there a letting any building. In view of the above discussion, this court comes to the conclusion that vacant land does not come within the definition of building under the Act. Therefore, the court has no jurisdiction to entertain the eviction petition filed under the Telangana Buildings, Lease, Rent and Control Act 1960. Accordingly, the point is, the petition is allowed. This already been charged. Sections of this must continue. That Rent Control Act is AP Buildings, Lease, Rent and Eviction Act or Telangana Buildings, Lease. It is a statutory tribunal. It is not a court like government tribunal, industrial tribunal, rent tribunal. This is a creature of a statute. It is not a regular court. The provisions of CPC are not applicable, and there are rules framed under the Rent Control Act, section 33. And also this book that may not be available. If the book is there, you'll also make it is section 30 of the Act. Rent control cases are to be decided as per the rules which are framed or to make rules. That section 30 says, yes, that is the rule making power. Yes. And under the rule making power, rules are made under today's Buildings, Lease, Rent and Control Rules 1961. Yes. These rules where there is no provision like Order 7, Rule 11 for rejection of a rent control. Anyway, the present application filed by the respondent to the division, which is at page number where the provisions, where show me the provisions in the rules, indicating the matters. States that the disposal of the cases or dealing with the rejection of cases. That's where the provisions. There is a group called powers of the appellate court. There are different rules to get. How do you 6 for it is relevant. That is about receipt of rent. Then to 8 euros per day. When application under the Act is presented to the controller, we shall fix the date on which and place at which the inquiry in respect to the application will be held and send notice thereof to the applicant. Agents are the respondents or respondents mentioned in the application and shall also send a copy of the application along with notice to the respondent or respondents. Then sub-rule 2 of Rule 8. The controller shall give the parties a reasonable opportunity to state their case. He shall also record brief note of the evidence of the parties and the witnesses, if any, examined on either side. And upon the evidence so recorded, and after consideration of the documentary evidence which may be produced by the parties, pass orders on it. This is the manner in which a rent control application will have to be adjudicated. There are provisions regarding deposit of rent and all that. Now, the case has not reached that stage at all. Yes. Petitioner filed a rent control case, respondent filed a petition to reject that on the ground. But the lease was in 1962. At that time, it was open land. Rents in 1962, I may give you an example to come. We have got one grand cafe near GPO, General Post Office. A big hotel sells biryanis. The rent is 55 rupees. Today, even today, the landlord doesn't even turn up to receive it because the traveling expense is more for him. But there are buildings which are leased out for it long ago in 1960s. So when I lease, both for it should not go into this aspect without the evidence on record. It is open,
admitting that there is structure there, not admitting that in the order, the structures are there.
The structures are there. Admitting that is a matter of evidence. It cannot be at this stage. But first thing is whether there is power to reject at this stage. The parties have not letting evidence. Such power is given under the Civil Procedure Code for Order 7 to 11. And similar power under the criminal law under Section 482 to quash the criminal proceeding.
Yes.
The tribunal, statutory tribunal will function as per the provisions of law and the rules made therein. It cannot apply the provisions. This is a direct judgment. Also, that Civil Procedure Code is not applicable. It is reported in 2005, Volume 2, KLT 486. Paragraph number 16.
Yes, I'm 16. Yes, sir. 16.
I thought my colleague will mark it as well. Citation to include.
Yes.
But paragraph number 16. Yes. Last about 6 lines. Since it has not taken into account the provisions contained in Section 30, subsection 2 of the Act, which has excluded the applicability of the provisions of Code of Civil Procedure to the proceedings under the Act. So, Section 30, subsection 2 is the statutory code. Let what section 30 subsection 2 of the Act itself says is on what aspects rules can be framed. Yes, under 30 subsection 1. And as per section 30 subsection 2, which the learned citation has referred to, without prejudice to generality of the foregoing provisions, rules may provide for all matters expressly required are allowed by this Act. The procedure to be followed by the controller and the appellate authorities in performance of their functions under the Act. The manner in which notices, orders under the Act shall be given. Setting aside ex parte orders passed under the Act, applications making legal representatives and distinct persons as parties to the proceeding under the Act, and time within which applications shall be preferred. Then F. The procedure to be followed for taking possession of the building and the disposing of the articles that are found at the time of taking possession. Then G. The leviable in respect of the applications and appeals. Then H. Any other matter for which there is no provision or no sufficient provision in the Act, for which provision in the opinion of the government necessary for giving effect to the provisions. So these are the matters on which the rules can be made and rules are made. And anyway, the petition filed by the respondent in the present case, the copy of the affidavit will also be filed at page number 22 to 27. Page 22, IA number 72 of 2022 affidavit starts. And the prayer at page number 24. For the prayer, kindly see paragraph number 12. In the light of the aforesaid, RC number 1 of 22 filed by the respondent is barred and liable to be rejected under Order 7, Rule 11. Application is filed under Order 7, Rule 11C. There are no orders under the Director Rule Act. Yes. Therefore, the order is without jurisdiction. There is a stand taken in the counter affidavit that I should have gone to the appellate authority. Section 20 provides for appeals against the orders and judgments of the rent control. If an eviction order is passed, the tenant can go and appeal under section 20. Thereafter, revision under section 22 to this court. That is on the merits of the case, but this is non-adjudication of the case on the ground that it is a written fact. That's not a petition. So such a fact that cannot be a ground for rejection of the petition at the threshold. Yes. Yes.
Maintainability. Because the Rule 11 application was allowed. Other passed with the London Court is akin to a decree now. Any appeal against a decree, there is a specific provision provided under Section 20 of the rent control. Section 24.
Appeal.
Any person agreed by an order passed by the control may within 30 days from the date of such order prepare an appeal in writing to the Chief Judge, Small Causes Court in the cities of Hyderabad and Secunderabad, and elsewhere to the subordinate judge, or if there are more than one subordinate judge, to the principal subordinate judge having original jurisdiction over the accused. In computing the said period of 30 days, the time taken to obtain a certified copy of the order of appeal shall be excluded. Specifically, there is an appellate procedure which is provided under the Act. And judgment, if I may just check, this is under the RDDP Act. Also a special act. Just one page judgment, which is para 6 of the judgment.
Yes.
The Act has been enacted with a view to provide a special procedure for recovery of debts due to banks and financial institutions. as a hierarchy of work is provided in the Act, similarly under Section 20 under the rent control. Namely, filing of an appeal under Section 20 of the fast track procedure cannot be allowed to be delayed either by taking recourse to proceedings under Article 26 and 227 of the Constitution or by filing a civil, which is expressly barred, even though provision under an Act, even though provision under the Act cannot expressly also jurisdiction of the court under Article 226 and 227 of the Constitution. Nevertheless, when there is an alternate remedy available, judicial rule demands that courts refrain from exercising its jurisdiction under the same Constitution. This was a case where the High Court should not have entertained the provision under 227 of the Constitution, where directed the respondent to take recourse to the Act. The provision is that Rent Control Act is also similarly placed as the RDBSI Act, which is a special act and a special tribunal has been constituted. And there is a specific appellate procedure prescribed measures remedies to apply before the concerned civil court measure, which is in this case the small causes as per Section 20. According to the merits of the case measure, CN has submitted the provisions of CPC are not as qualified. Attention to page 308, page numbers are page 308, unnumbered paragraph 2. In the middle of the paragraph, it is true that unlike in various other enactments. Yes. It is true that unlike in various other enactments, there is no general provision stating that CPC is applicable to the proceedings under the Act as far as practical. It is also true that whenever any provision under the Special Act is consistent with the provisions of CPC, the formal provisions will prevail in Section 14. These circumstances, in our opinion, do not prevent the application of civil proceedings under the Act, either in cases where the Act or the rules do not make any provision, and cases where any of the provisions of the CPC are not inconsistent with the provisions of the Act or the rules or general scheme of the Act. The Act being referred to here is the Rent Control Act. Subsequently, they gone on to discuss this at length. There was a continued on page 09. I refer to another judgment. I talk about Chettiar versus Chandrasekhara Raiwar. So again, in the middle of the paragraph, if the Act and the rules are silent. Yes, sir. If the Act and the rules are silent with regard to any specific procedure, you could follow that the relevant provisions of CPC would be applied, provided those provisions are not inconsistent with the purpose and scheme of the Act. It has been accordingly held that the Rent Controller has the right to order amendment of the lines of Order 6, Rule 17, rights of principle. In that decision, reference was also made to the principle that where enabling statutes omit some detailed procedure, the courts have ancillary powers to deal with the situation appropriately. And following passage from creation statute, so was cited. If a statute is passed for the purpose of enabling something to be done, but omits to mention in terms some detail which is of great importance, if not actually essential, to the proper and effectual performance of the work which the statute has in contemplation, courts are at liberty to infer that the statutory implication empowers the detail to be carried. Similarly, it was said by one of us in CRP number so also that the Rent Controller is entitled to apply the provisions of Order 20 CPC and direct restoration of possession to a stranger of a portion of the building which has been delivered to a landlord in an eviction petition. Consequently, in that case, it was then the Rent Controller can apply the procedure contained in CPC in matters in which the Act or rules made under assignment. But the bottom fourth line. Nevertheless, the other principle laid down in the decision that where any special or local laws which to provide any procedure to be followed by the tribunal, the tribunal is entitled to perform the rules laid down in the CPC, which is derived from the effect of several conditions. That judgment still remains. Bench of this or High Court has held that the provisions of Order 26 CPC are applicable to the proceedings before the Rent Controller by unreported judgment. Last paragraph of 310. We are inclined to agree with the view of CPC would as far as to be applied to the proceedings under the Rent Controller Act. In cases where no adequate provision is made in the Act, or the rules and provided in the provisions to be applied are not inconsistent with any express provision of the Act or with the scheme and purpose of the Act. My humble submission is that there is no specific procedure for rejecting a petition at the threshold level. Accordingly, because the Order 7 Rule 11 is not inconsistent with any specific procedure prescribed on the Rent Control Act. Procedures or provisions of CPC can be all influence into the provisions of the rent control. I just mentioned one more judgment. Para 22 economic potential. Right. Yes, going back further, we are of the user. Yeah, maybe apply the alignment. Yes. So far as the particular system of the act may be applied by navigation whether even versions of the principal underlying can be applied to scheme under the rent control act from the further goods made there and the judgment covered by a judgment also specifically held the provisions of CPC can be read into the provisions of the rent control act as long as they are not inconsistent with the rent control act. The submission is that the petition which has been filed is under the Rent Control Act, Section 10 of the Rent Control Act. The provisions of the Rent Control Act are applicable only to a building as per the definitions given under the Rent Control Act. And what entitles a particular property to be termed as a building is has been defined under Section 2 of the Act. Common attention to the definition of building. Building has been defined as any house or hut, part of a house or hut, let or to be let separately for residential or non-residential purposes. And includes grounds, garages, and outhouses if any tenant to such house, hut or part of such house or hut, and let or to be let along with such house or hut or part of such house or any furniture supplied for any fittings affixed by the landlord for use in such house or hut or part of house. But does not include the room, hotel, or clause B of any furniture supplied or fitting affixed by the landlord. So what if any superstructure has been constructed by the landlord, that will come under the definition of fitting. In the present case, only vacant land was leased out to Bharat Petroleum Corporation. All superstructures which were constructed, which are the dispensing units, pure dispensing units, the shed of the petroleum, that has been constructed by Bharat Petroleum. So these are technical equipment the landlord is not capable of making such construction. Based on this definition of subsequently the definition, say for example, the definition of landlord. Landlord means the owner of the building. Tenant, specifically, the Rent Control Act is applicable only for adjudication of disputes between the landlord and tenant, only with respect to a building. The Rent Control Code does not have jurisdiction to entertain the petition itself in the first stage, because it is beyond the scope of the act. Because leased out was mere vacant land, and whether Rent Control Code has jurisdiction to entertain a petition concerning vacant land, concerning lease or rent of vacant land, is what was challenged in the Order 7/2011 petition. So the proceeding further with the adjudication of the dispute would be beyond the scope of jurisdiction. It would be beyond the jurisdiction of the Honorable Rent Control to proceed further with the matter, because he does not have jurisdiction as per the act. He is only entitled to adjudicate upon disputes concerning a building. Anything beyond the building is not permitted to be adjudicated upon by the Rent Control. Accordingly, we have filed an Order 7/2011, specifically SAP 11D memos, that it is barred by law, because the fact that only vacant lands are leased out, it is an admitted fact because that is common for the attention. para 8 of the order memo. Yes. And para 8 of the order memo is specifically stated regards to again going back to whether versions of CTC are applicable or not. The point was argued before him also. The second law that every proceeding under the Rent Controller Act is to be governed in accordance with the provisions under the same Act. However, in absence of any provision, reliance can be made upon the provisions of CPC, since there is no specific provision under the Act regarding rejection of rent. Therefore, this petition is filed under Order 7, Rule 11, which provides that, and he has accepted that provisions of CPC are applicable. Okay, paragraph 14. Reviews the documents filed by the respondent petitioner. The petitioner, that's the landlord, yes, along with his eviction petition and counter filed by the landlord in the Order 7. Respondent petitioner himself admitted in his counter filed in the petition that initially only vacant land was let out by erstwhile vendors of respondent petitioner to petitioner respondent petitioner. For running a petrol pump, the petitioner respondent, that is the tenant, had built superstructures over the vacant land with the permission of the lessor. Now, the specific admission is also made at mechanic for use page 30 of the petition, because in their counter, specific admission has been made. Paragraph 8 again. Yes. 4th line. Submit that the schedule in the lease acknowledges that the permanent structures on the land were built by the petitioners herein, that would be the tenants, were built by the tenants herein, which was with the permission of the respondent herein, but that does not construe that the same does not fall part of building as used for the petitioner. It is an admitted fact that mere vacant land is the petitioner has not filed the lease deed or the basic. Based of the entire dispute originates, because the schedule of the lease deed specifically states that only vacant land is being leased out, excluding the superstructures therein. Let me pass on the submissions which were filed that has is the schedule extracted. Paragraph 4 of the written submissions. Each document has not been filed. Paragraph 4 the schedule which is specified under the lease deed has been extracted. All the trees and parcel of land, excluding the superstructures already rented. What was leased out is mere vacant land. The controller has rightly come to the conclusion that it does not have jurisdiction to adjudicate upon a dispute which is concerning only vacant land, as it does not come within the scope of the Act. The definition of building is restricted to any superstructure which is built therein. If a 1 acre plot has been leased out, may have only a small buggy or a small hut at the corner of the house of the plot. Even then, it would come under the purview of the Rent Control Act. But as long as only vacant land is leased out, purview of the Rent Control Act is restricted. That vacant land cannot be adjudicated upon by the Rent Control. The Rent Controller has also relied upon the judgment of this HIGHCOURT. State that building cannot be a vacant land. It's been extracted in the order also. Unnecessary sugar means. Unnecessary sugar means it just passed on. Just read the first and second paragraph. Subdivision petition number 61 of 2006 was filed by the tenant, detailing the concurrent findings of that he committed willful default in paying rent. Subdivision petition number 5327 of 2004 was filed by the landlord, detailing the finding given by the learned senior civil judge in their area evidence order that the premises in question is a building coming within the definition of building as given under the Act. Paragraph 21 onwards. Yes. Srimati J.C. Sarati, learned counsel, seeks to rely upon the judgment of the apex court in Koti Sarojanamma versus Chandrakanta Malleswara Rao in the judgment rendered under the provisions of the Act. As can be seen from the facts of the said case, the property that was subject matter of lease was sawmill machinery and land consisting of approximately 10,000 square yards. Sawmill machinery was covered by a zinc sheet to protect the machinery. Having regard to the same, the apex was of the view that is of the sawmill machinery, but it was not a case of lease of a house or a hut. Which is the subject matter of lease was described as under the property mentioned in the schedule. Next consists of vacant site, zinc sheet shed, and machinery belonging to the plaintiff here and coming to the facts of the instant case, the lease was for the purpose of establishing a Kandasari sugar mill. Construction of other superstructures apart from the original premises in which the plant was located was passed subsequent to the lease. The decision of the apex court therefore squarely applies to the facts of the instant case. Yet another judgment ought to be relied upon by the current council. The judgment was entered in London. The property that was subject matter of device was 49 square yards of land, along with the shed existing there. What was the view that the improvised shed as described in the plaint as well as in physical evidence it was put out by the tenant later on. And the lease was obviously in respect of only vacant piece of land. The premises not square only not square.
Show me the petition copy, sir. Show me the petition copy. Filed by the petitioner.
Is the petition errors. Page 57 is the schedule which has been extracted.
All pieces of parts of the land
and situated at some other the boundaries is along with constructed area existing plan.
Yes, constructed area means including.
That is what they have stated in the schedule. Rest. So can you produce the order also? It has been specific.
Yeah, the electrical plate was taken up to paint not by the counters by the
what software? What by counter?
mentioned as the constructed area means. No, once constructed area is there.
No, matters. On submission matters. They have specifically they are misrepresented in the plane. So the schedule of property
and decided only taken up only plane and the documents along with it. That's only.
Yes.
Not by the.
Yes. Documents along with the plane. That's the lease deed. Yes. The basis of which the dispute has been.
There by the title is not by the register ID. Artisanal levels.
We are only going by the documents filed with the plane. There is a lease deed.
So let's show me the documents.
That document has not been annexed with the present CRP minute, which is there.
Therefore, I have seen the documents. So you will file a collab with the count, otherwise, ask them to file the documents.
Let them file a copy of the lease deed minutes, which is marked as document number 6. Also, kindly page 58 minutes. List of documents, certified copy of the registered lease deed, document number 6 and document number 7. Let them file a copy of the document memo as filed with the learned and controller. For display matters, the schedule which has been specified in the lease deed is different from the schedule which is specified in the petition. The learned and controller matters has come.
Where is the markup? Where is the markup documents? They not no document marked by the rent controller.
No rejection.
Yes, sir. No. Where are the documents? They're marking there. I want the document there. Specifically mentioned here that constructed area. Once constructed area, building means.
Constructed area that has been misrepresented. The rent controller has come to the same finding also.
Admitting that the construction is there, the building. The rent controller.
That is what has been filed by the petitioner. You need to bring it within the ambit of the rent control board. Under the ambit of the rent control act, it has specifically added this one line about the schedule. What is actually there in the schedule of the lease deed is what has passed on in the written submissions.
Just last time. Syracuse totally come. Para. What para number? Structure is there. Structures are there in the.
No structures. Structures were built by me. They have admitted that in their counter also.
As it stands, on the date of filing of the rent control,
yes,
as we see,
yes, sir.
This petition was filed on 10th August 2022, as per the schedule at page 57.
Yes, sir.
And my in front is arguing about the lease deed, which is at page 58, document number 6, certified copy of the registered lease deed, bearing document number 964 of 1962. And at 1962, it might be open land, but any person who purchased open land on thereafter constructed building. Now this petition is made for eviction of building only at 500 square yards each. Now he says that I should file the petition only on the basis of the schedule mentioned in the 1964 lease deed.
Yes.
Rights of the parties, first principle of law is rights of the parties are to be adjudicated as on the date of institution of the list.
Yes.
On the date of filing of my petition. Not in the 1962 or even 100 years before. Everything was very limited 100 years ago.
Yes.
Now multi-story buildings have come. Therefore, the schedule now I want to praise him because he made some research on this. But I will tell you, I should let me give a chance to argue. First submission is that the schedule of property in the rent control petition is the only basis which should have been taken into consideration by the rent controller at this stage when this particular petition is entertained.
Yes.
And not 1962 that there it is mentioned as latest and when 1962 painted land was that was the value better. Now there is a description which now he says that this is only a ruse, but that is to be established in evidence. That's not at this particular stage. Second submission is this petition is filed under section 10. All the judgments of the file, clarified the bench and Vivian bench, all they deal with the case relating to if there is no inconsistency between the provisions of the Rent Control Act and the Civil Procedure Code. Civil Procedure Code can be applied to Rent Control Act also. That is the proposition right. Yes. But this petition is filed under section 10. It is in section 10 provided only for eviction. My prayer is not that he should be hanged. Petition filed under section 10 of the Act.
Eviction of tenants.
Eviction of tenant. So on the ground that there is willful default, bona fide requirement, there are the grounds mentioned under section 10 of the Act. So this petition has to be decided. It doesn't want money, every tenant wants avoidance of the adjudication of eviction petitions. So the threshold objection is that it is a vacant land, therefore rejected at this particular stage. Even if I had a fight, a suit, you would have taken a stand that it goes to Rent Court, therefore suit is not going to take.
Yes, sir.
Yes, definitely. This argument is advanced by many of the tenants who are very much glamorous about that particular premises which they are in possession. As I told the Grand Cafes Hotel's case.
Yes.
Even before my birth, it was there. That poor landlord died, his ransom was 850 rupees. So now, the date of filing of the petition, the prayer made in the petition, now section 20 appeal remedy is shown. If an eviction order is passed, or if my eviction petition is dismissed, section 20 will come into play. Not this rejection. Order passed by the rent controller. Then order passed under order 7 rule 11. And these judgments say, your worship kindly see the judgment of Justice Allard. That is the judgment which is handed over to the Honorable Court. The APLJ, which has disappeared now. I am not able to say that APLJ 1969, page 290.
Yes, sir.
So Justice Gopal Rao reported in this. In that, your lordship may kindly see the opening part of the judgment. Page number 295. Judgment of the bench rendered by Justice Goswami. Can you see the last para, that same page?
Yes, sir.
The main act does not contain any provision indicating the procedure to be followed by the rent controller in dealing with the application under the act, whether they may be for fixation of fair rent or for eviction or in connection with other matters provided with the act. It is, however, provided under section 30 of the act, the government may, by notification in the official gazette, make rules to carry out the purposes of the act. That subsection 2B of that section, without prejudice to generality of the said provisions, such rules may provide for the procedure followed by the controller and appellate authority in performance of their functions. In pursuance of the powers under section 30, the Andhra Pradesh Buildings Lease Rent and Eviction Control Rules 1961 were made. the rules which are relevant for the purpose of considering the question before us, the following. Rule 8 was subject matter of consideration activation in that case. So this judgment is not an authority to say that wherever there is no provision in the Rent Act, borrow provision from Civil Procedure Code, insert Order 7 Rule 11 also into rent control cases. Every tenant, if this is encouraged, what happens is consequence. You will see. For any judgment in rent act, the consequence also has to be looked into. If the Honorable Court holds that Order 7 Rule 11 is applicable to rent control cases also, every rent control case, first aspect which the rent controller has to decide is whether it's a case for rejection of the petition or not under Order 7 Rule 11, which will be taken for 4 or 5 years at that particular stage. And if it is not a case for rejection, it will go back on it to the rent controller. And the eviction of the tenant, landlords are already suffering because of this enactment. I call this enactment as an archaic and outdated enactment. Because I am the landlord, I am taking to possession. The tenant will not vacate unless I break out these grounds. But in 1960, when the Act came, there was a scarcity with regard to the lease of houses. The law at that particular time was made with a different purpose to protect the tenants. Now the tenants like Spencer, tenants like Ratnadi, they are not paying rent. Landlord is not able to file eviction petition because if they vacate that building, nobody will take. He is saying you pay at least half, you continue to be in this. But your Lordship's consideration also may kindly take into hold that if this Order 7 Rule 11 is universally maintainable in all rent control cases, then the learned judges sitting as rent controllers will only deal with Order 7 Rule 11 application and not the rent control cases on merits. So when that's called purposive interpretation of a statute. The purpose of the statute would be defeated. And the reliance about this RDDP case is a different thing. That is Recovery of Debts Due to Banks and Financial Institutions Act. There are appellate remedies. Bank files a OA against a defaulter. Then anybody is defaulter cannot challenge it under Article 226. He has to go in appeal before the appellate tribunal under the RDDP Act. Same is Securitization Act also. That is not comparable to this. Here, the hardship cannot be shifted to the landlords. He can contest all this money with his evidence that there is no building, how much portion of the building, and the court can come to a conclusion after recording of evidence and marking of documents. Not go away petition like this summarily. Yes. So, production of that 1962 lease deed made today, in my respectful submission, does not serve any purpose because I admit that in 1962 it is vacant land only. But earlier Rashid Marad has argued that in 1961, Banjara Hills, value of acre was 30 rupees. There were no buyers because it was all a rocky area. Construction on those rocks was not developed as per engineering technology in 1960. Now, that is the beauty of the house. The house will be on a rock. Then the water flow coming out like a fountain. That is a different thing, the technology has changed. So, that lease deed of 1962 has no relevance. And appellate remedy, and none of these statements say Order 7 Rule 11 should be applicable. And if such a law is laid down, it will lead to unreasonable hardship on the landlords. Therefore, the participant before the landlord is not evicted now. He filed a petition for eviction. He has not filed a counter also.
Okay, yes, sir. The reply. I was saying the word plain. What is player in the plane? There is a sheet is represented. Senior also. 1962 document is on the basis of which they are seeking for eviction. These was given as per the 1962 document that is still subsisting till today. It is on the basis of that document that they are seeking for eviction. Now, superstructures were subsequently built by the respondent, that is the fuel company. Yes. And similar to the case in the sugar mill case, the vacant land was leased out and sugar factory was built. Sugar mill was built by the tenant. And that's just specifically held that here vacant land which was leased out cannot
even after infrastructure is being built by the tenant, cannot be brought to the definition of building. Paragraph number 12 and 13 of the the post fadas, table sets, post fadas, 3 weeks. No mention exception.